Bunch of things. So what we are trying to do is a different format. Let me get my co-speakers also, Anil and Gosakan.
Gosakan is here. Hi.
We are kind of keeping it pretty short nugget, 15-minute discussion, a new format that we are trying to say because so that we don't put you to sleep, and we fought for the morning session. It's kind of heavy, therefore we kind of talk at a very high level some of the important things through your journey of early stages. I'm an India lawyer, and thank you so much, and good morning. And Anil is the US attorney. And
I'm also Indian, by the way.
Some of the things that we were thinking as most of the startup product company, software product companies are going global, we found it really, really important that we give both sides of the story, the India side and the US side, and what makes it global and how do you protect. So thank you for being here. What we're going to do is take the 15-minute short topics. If we have time, we'll kind of take a question each during the session. And then we are going to have a 30-minute, maybe 40 minutes of Q&A where you can ask any question that's kind of troubling you. Ready? All right. Thank you so much, and I will get Anil and Gosakan to kind of jump in as they kind of deem fit. Gosakan, would you like to join us? Largely focused on startups and SMEs in technology space. Been here for about nearly 7 years now, and it's so nice and warming to see the same 25 to 50 people attending a session to when you open up a session at IMB, it's like 400 people and not many known faces. I think India is at a stage where there is huge growth that we are expecting, and now the impetus, so it's been in the early stage of starting up a lot in terms of IP that the government did. So 2005 we saw a lot of changes in the patent law, etc. And there are kind of investments that we are seeing right now in the angels, the seed stages, kind of started at around 2010, and it's been a good run. With the new government, I'm expecting, and I'm very hopeful that the circle of the entire journey kind of gets completed, which is people starting up through the continuum, they get funded, they get acquired, and those people kind of again become angel investors. I'm seeing that happening, and that's the warming thing. I also believe that there would be a, give me a minute. I think there will be a very robust IPO market that might be coming in also with the new government, and the people who kind of support the new government also. So here we are. I think the journey will be good for the next 6 to 10 years, and you're in the right time starting up. Yeah. So for today, what we're going to do is the nuggets that I was talking. Some of the prenup for the startups, the founders agreement, do you need it, and why do you need it? The kind of setting up an entity in India versus maybe Singapore, maybe US, and where in the world can you be as an entrepreneur who is very confident of going global. The different sides of the story, how do you get it operational? And if you started your entity in India or in US, what it means to flip it the other way around. Yeah, where should the holding company be? Where should the sub be, etc. And then we are also going to talk about structuring the first ESOP plan, both sides of it. So the India side and the US side, how does it stack up? What components, what do you need to think about? India is very complex, and Anil will kind of take us through what it means in the US side. And Anil will also be talking about how to build a board of advisors across the world, if at all, or generally, how do you build your very competent board of advisors. And Gosakan will be talking about patentability of software products. Yeah? Why a founder's agreement? Many a time, the co-founder is someone who you have known for a while. Could be someone in college or kind of work together, and you're kind of coming together now. So what happened as a change is the social relationship that you kind of had is now getting converted into a working relationship, economic benefit relationship. When that changes, a lot of things has to be spoken about, and perhaps the best time to speak about them is when you're starting off, because these are kind of sensitive. You feel a little awkward when you're talking to a very long friend or your hostel mate in college perhaps. So this is kind of spoken to clarify a lot of expectations between the parties. So founder is not a defined legal term. It's now that in our new Companies Act we have a term called promoter as a defined term. So I'm going to use the word founder as someone who starts off the business. Okay, it could be different designations, but founder in the sense who starts off the business. The reason why you would like to have this upfront or much earlier during the journey rather than later is to clarify some of these things. The roles and responsibilities. Now, there are different businesses that will need different kind of skill sets, and these skill sets also change over a period of time. So, for example, let me take a bad example, a startup which kind of went bust. Most of you would have heard Taggle, the deal discount site. Ivy League founders, but what went wrong? So here is a skill set that the team brought in, which is largely marketing, etc., which is what the deal discount site required. But just about everybody kind of got into the same space when the investors kind of forced them to pivot and become a e-commerce platform, which largely is distribution and logistics business, if you will. So when that pivot happens, the founder said, that's not the skill set that I have. And therefore he stepped out. And the moment the main founder stepped out, the kind of whole organization kind of collapsed. So there are a lot of these skill sets that are required, and pivots do happen in startups, but it's nice to know that there is a large complementary skills available in the founding team. Investment versus sweat. Every business needs money up front. Maybe it's a little cheaper to start a IT business now, given the kind of free storage to not expensive storage to all of that. But nonetheless, you need money, and you kind of typically founders kind of bring that money on from their savings, and many a time it's largely sweat. So there is a discussion amongst the founders of how much is the money required over a period of say 12 to 18 months, and how much will each one bring in, and would that all be sweat, and if so, how do we kind of come together to take the company off the ground. Then there is equity holding, which is the biggest component that's a discussion. I'm going to talk about it in the next slide. But primarily you talk about how much should each one have, what is the vesting schedule, and very, very importantly, what happens when one of the co-founder leaves, or if it's a nice handshake versus an acrimonious handshake, an acrimonious leaving. And if such a situation arises, then how does the transfer work? At what price does that transfer back to continuing co-founders happen, are some of the components that you will capture in the founders agreement. Designations. This was a interesting example. Just out of college, 3 co-founders, and the biggest discussion, which I expected was on equity, was on designations. they were fighting over a designation because they're just out of college, and calling themselves the CEO, etc., was fancy for them. And I thought that could also be an issue, and therefore we kind of bring that upfront. The second piece of it is also how certain designations kind of is viewed outside the founding team. To give you an example, so 3 co-founders came together for, it's an analytics company. They were at a coffee table and they said, I don't want to be a CEO, I don't want to be a CEO, and the other guy by default became the CEO. And when they raised the first round of funding, it so happened that the investor was so focused on kind of just speaking of all the terms with the CEO leaving the other 2. It was not intentional of the founding team, but it got viewed that this is the guy who will be taking the decisions, and therefore all the discussions were kind of focused towards him. Director versus shareholder. Sometimes you also have co-founders who is perhaps still working, getting a salary, therefore he can support the startup. Now, internal policies of that employer is important to be viewed. At the same time, can he be a director or a shareholder is something that you need to see. So director is someone who is in control of the management of the company on a day-to-day basis. Shareholders are the owners of the company. They own the shares of the company. And typically it's the same set of people in early stages, but these are 2 different roles. Decision making, it's important that at early stages it's almost a democratic way of decision making. All of them are kind of sitting next to each other, at work, and the decisions kind of keep happening all the time, and there are a ton of decisions that come on a daily basis to be taken. While it is nice that it is a democratic way of decision making, at some point there has to be consensus that, okay, this is it. This is the final decision, right? It can't go on and on a debate, but at some point someone will have to take the call and saying, okay, this is the final decision that we are taking. And who would that be is one of the things that the Founders Agreement talks about. There are other aspects of controls. For example, should the bank account be a joint signatory? Or who should be the signatory for the bank account is one of the things that I have seen come up in the Founders Agreement. And then you have all IP that has to be assigned to the company, the new legal entity versus the founders in their personal names. And when we do this first round of funding, almost always we see that the domain name is in an individual's name, and should there be an issue of someone leaving, then the domain name is with that person and we have a problem. To take an example, there were final year engineering graduates. They came together they worked on open source stack, and they came up with this doctor appointment SaaS product. And one of the founder left the organization. The domain name was his. It was in his name. The name was proposed by him. Some of the OpenStack work that he had, he claimed that all of it is his. He had moved out of the company, and we were raising some substantial money from our IV investor, and we had a problem. This co-founder, the forgotten co-founder, came back claiming at least 33% of the company because he thought the software is his, the name is his, the domain name is in my name, so I claim 33%. And so what we did was, there are other ways of dealing with it. We changed the name of the company, etc., etc. But it's nice that at the time that you're putting the foundation for the company, you ensure that all of the smaller stuff that we kind of tend to oversee are not smaller stuff. Right? And we also talk about in the founders agreement that the founders will not start something similar, will not compete with the company's business, will spend substantial time in the company. If he were to leave, he will not solicit people from the startup, are some of the things that we kind of see. Oops. Founders equity. So how much should each one hold? If you're expecting a formula, I'm so sorry, there's no magic formula. What it is a function of the following. The role that is required as a part of the whole business. So is it a market-facing kind of a role? Is it a tech-facing kind of a role? Is it the operations kind of a role? All of these different roles are required for an organization. But how important is each one of those, and how important is it as a larger set of things is what determines one of the criteria for what the stake should be. Investment for cash or sweat is another discussion. Joining at the beginning of the journey, or sometimes you kind of get a co-founder perhaps at 8 or 9 months, 12 months down the road. So how much equity for someone who joins in late? Salary, as in, is this co-founder taking a higher salary, therefore lesser equity? These are some of the things. There is no formula. These are some of the parameters that you would kind of have a discussion on before determining what that scope could be. Can it be 50-50? 3 of them, therefore 33% is one of the ways of doing it, but is that the right way of doing it is what this discussion kind of helps. Enforcement, big word. What I only meant was, how do you do this? Should it be just all of you kind of putting that on an email, or should it be something where you print it up, everybody signs, that's it? Or should you make it enforceable, which means you include in the articles of association, because now that becomes a charter document. But each of it has its own different things. So if it is in the articles, then it can be that much more restrictive because it's in your bylaws. For you to change each of the time, those clauses will mean changing the bylaws each time, which is a legal process. If it is just an email, people can claim, I didn't know it, I didn't receive it, kind of a thing. Should it be an agreement? Perhaps yes. In this country, enforcement takes a very long time, and this will be a civil case if something went wrong, or if you can include that, even though it is shares and not a part of the articles, then it goes to the civil court, 7 years. So enforcement is a bit of an issue. So there are other ways, mechanisms of making this transfer back kind of work. Perhaps you can have a share transfer deed signed up and it's available. You have different ways of getting this enforced. They also spoke about the vesting clause in the founders agreement. Now, there is a date when the founders agreement kind of starts the vesting clause as. Could be annual, monthly, 2 years, 4 years, whatever is the discussion. It is nice to have a founders agreement upfront, because when there is an angel investor coming in, you can say, you know what, we have this vesting clause already in and we don't want to reset it, and therefore please honor the founders agreement at the time the investment comes in. So that's an advantage. If not, most of the times what I've seen is when the first round of investment happens, the vesting clauses kind of gets set from then on. So it will be 4 years from the date the investment is kind of coming in. So these are some of the inherent advantages of having a founders agreement. If you have a very quick question, I can just take one. possible, but if you look at the intent of a founders agreement, in the sense it is for clarifying some of these positions, then it is helpful, but it's not a legally enforceable document. Yeah. All right. So let me call Anil over, and how would you like to?
While we set up my presentation, and it's a short one, I promise, let me throw in a few more comments on the founders agreements, or even turn a question around. Sharda made a great presentation for why you should have a founders agreement. How many of you are convinced that you need to have a founders agreement when you get started? Great. Let me add a little bit more flavor from a US, or at least my perspective. How many of you have heard of a company called Facebook? Okay, all right. You don't have to raise your hands. There are two guys who will go to their graves believing they own Facebook. And the only reason they don't own Facebook is because they didn't have a simple agreement with Mark Zuckerberg, where they would have allocated equity to Mark Zuckerberg as a first employee and to themselves as founders. So the difference between owning a Facebook and chasing a Facebook with litigation is to actually have a founders agreement between whoever is going to be the founders and identifying the founders initially, and then having the guy you're hiring to create the code and also enter into a written agreement agreeing on what his role and responsibilities will be. So I just want to sort of add that to the flavor. I've worked with over 1,000 companies, and I'm not saying that just because it's a good number. I'm saying that because I have a very interesting stat. If there are three founders, and if there are three founders that start 1/3, 1/3, 1/3, what is the percentage you think that will lead to litigation? 70, 80, 90? In my experience, 100%. And I say this, and I go out on a limb, over 1,000 companies that I've worked with, where the founders come in agreeing to, because they were friends in college and now they're becoming founders or co-founders, they agree that we're all friends, we don't want to have this difficult discussion about founders' equity, so let's just start 1/3 and we'll figure out. 100% of the time you will enter into a litigation. There'll be some sort of a falling out between and among the founders, and you would then regret. So the short phrase I use is, it should be fair, but fair doesn't mean equal. So just remember that next time you're negotiating among the founder group. So with that, I'll get started with my presentation. Sorry, Sharda, I just thought I'll add some flavor there. As I say this, this is, as a lawyer, this is sort of the most colorful I can get. So enjoy this presentation. The rest of it is all black and white. This is just a typical life cycle of a startup, and I'll quickly go through it. Almost all of you are familiar with the various stages of a startup. You start from the start. You raise a typical angel round. You use that money to develop your product, sort of clean it up to a point where people are interested, customers are interested. You start signing up customers. Hopefully you've got customers that are paying customers, and you can put them on slides, make a compelling argument or presentation to investors, and raise a lot of money in the form of a Series A financing. And by the way, Series A, B, C, D are just sort of terminologies that lawyers came up with, and as creative as lawyers can be, that's all we could think of hundreds of years ago when we started this. So that's really it. You would raise your small round or a big round at the end of Series A, with typically around $2 to $5 million. Use that to then develop the product even further. Hire world-class team. So hiring a key large or a good team that's well-recognized industry leaders is very important to actually take the company to the next level, which would be your Series B customer, which is where you start working with big clients. And it's very important to have the right people, because especially in the US, and I expect it's in India, the ability to open doors to large enterprise depends on who's knocking on that door, not necessarily the product itself. So having those people, and in order to get those people to join, you need to have the right investors behind you, and that's where and enough money to be able to sort of attract the right people to join the team. So keep that in mind as you sort of develop your business plans. And I would always suggest that think about something along these lines, even from day one, of how the venture will start and grow. Most companies actually fail either from zero to Series A because they're not able to raise the first round of funding or first round of significant outside funding, or once they've raised Series A, most companies actually end up getting Series B, but then fail between Series B and Series C, because that's where they start working with the big customers, that's where your bigger competitors also start paying attention to what you're doing and start trashing you down. So you have to be very careful about having enough money, enough team, and sort of having a right strategy, and knowing that this is where you're more likely to fail after you've raised your 10 million or more of financing. So anyway, so that's, any questions on this? It's just a simple slide that I wanted to throw out there. So this is really the meat of my presentation. So this is one slide, and to the extent you can memorize it or copy it, or it's free, and I can sort of email it to you as well if you like. But from my perspective, and we talked about, and we will talk about, when you're starting a company, whether you should be a India-based company or a US-based company or a Singapore-based company, I can break it down in a simple sentence. You'll be foolish. You'd be absolutely foolish if you're starting a startup and a technology company to not have this on sort of as the final goal of where you need to be. We'll talk about why, and I'm sure Sharda will bang me on this and have her thoughts on India company. But and so as I said, we'll talk about why you need to be there. But this should be your final goal. This is where you would set up as we call it, a C corporation in Delaware, and we can talk about why Delaware and why not Delaware. The short answer of that is, Facebook, Google, Intel, Apple, any company that you aspire to be is a Delaware C Corp. So if that's not good enough for you, I'm happy to go into more sort of legal and sort of philosophical debate about why not Delaware. But that's really, you're looking to set up a company that walks, talks, smells like a successful company that you're aspiring to be. So that's a US Delaware C Corp. That company would then set up a 100% subsidiary, so that's all of the stock of the India Private Limited company will be owned by the C Corp. But this is where you will be as founder sitting in India, and all your team will be employed in that India Private Limited company. So you will be employed here. All the work you do, and we talked about, Sharda touched upon, all the work you do here should be assigned to your employer, including the domain name, all of the technology you're creating, all the assets you are developing on behalf of the venture should be assigned to the private limited company. There'll be a services agreement between the India company and the US company, so that all the work done in India will be assigned to the US company and owned by the US company. The goal is to actually set this up as like any other startup in Silicon Valley, so that when you go out and start working with customers, they look at you or your company as any other technology company that they would work with, they themselves being, in most cases, Delaware C Corps. So as you start working with Facebook or Google or Apple or Cisco or Citrix or whichever else, you're presenting to them a company that looks exactly like they look. They all have development centers in India, and almost all of them do. They're all Delaware C Corp, so they start negotiating and sort of start engaging with you here. This is where you'll also raise your seed investment. This is where, including from investors in India, and we work with almost every seed investment firm in India, at least the larger ones. And I can tell you that many times they started by investing here, and we'll talk about the flip, and it becomes very complicated to then reincorporate and flip that into a holding structure here. So from my perspective, you want to start with this. You really want to start with this so that you make it easier for yourself to get to this stage. So you have a question on that?
I just wanted to know, understand, is there a benefit versus a US incorporation versus a Singapore incorporation? Because we see a lot of companies which are targeting the APAC market, not necessarily a global market. So
right.
I wanted to know if there's any particular difference between the two and what's
right.
beneficial.
Should we talk about that now, or should we talk about that? Okay, right. Singapore is if you were sure that your market was APAC and not US. And I hear this a lot now, especially in India, because there's advisors in India who are pushing for, some investors, but mostly tax advisors who are pushing for incorporating companies in Singapore. The only question I ask is, what are you planning to do? Are you starting a company because you want to save on taxes, or are you starting a company because you want to grow and make it a successful venture? Facebook when it started, Google when it started, I'm sorry I'm throwing these big names, but they tend to get more attention than just my saying it. Facebook when they started, Google when they started, Apple when they started, they all had great tax and legal advisors. But for some reason they decided to be Delaware Corp. They also had the option of being in Singapore in order to become global companies, but they all decided to be Delaware C Corps. So if you don't listen to me, at least listen to sort of follow what they've done and how they've become successful. And we can talk about the fact that there aren't a whole lot of tax advantages in any case, for you as founders sitting in India, because you'll still be taxed in India for any income or capital gains in a Singapore company, so it doesn't matter. If you're an investor investing in an India business, it might make sense for you to set up a Singapore company to get advantage, take advantage of the India-Singapore capital capital gains treaty. But as founders sitting in India, there's really no advantage. So from my perspective, the short answer is US, unless you're sure that you will never be in the US, or you'll have investors from Middle East or other places that may have concerns about investing in the US. So other than that, the short answer is this is what you want to be if you're looking to be a global technology company.
Most of us, let's say, did not create a US Delaware corporation, or let's say even if we created, I'll give you a scenario where the Delaware corp was created, the founder came to India, India entity was created, both are independent with only the shareholders, some shareholders being common. Now there is a majority shareholder. At the same time, India value has been created a couple of years, and there is no formal agreement between the two. In this scenario, do you still advise this 100% stock ownership, because then the fair market value and all that stuff comes in?
So you personally, but you'd be foolish to have done that and then worry about those issues. So what I'm trying to emphasize on this slide is that this is where you want to start. And we'll talk about, and Sharda, I'll need your help also in sorting out, if you're already there, if you are an India-based business, how do you flip into a US-based business and get to the structure? We'll talk about that separately with sort of potential tax issues and how to get around those. Oh, that's easy. So you promised to do that throughout the evening, right? Throughout the afternoon. Just okay. So anyway, so this is where you'll raise your initial seed round. Now you are a Silicon Valley-based company. Nothing's changed. Keep in mind, you're still sitting here. Operationally, nothing's changed. There's an India private limited company. You just put you dressed it up with a nice Delaware C Corp, so that now you can present to customers. When you go and start raising funding, you're looked at as a Delaware corporate, so you're looking at a much higher valuation. People are more comfortable investing because by the way, as I mentioned, all the IP will be assigned here, so owned here. You'll have filed patents in the US under the US company name. So investors, customers doing diligence in the company are comfortable that they're working with a company that's set up very cleanly and very properly with all IP issues taken care of. This is where then hopefully, as we looked at the chart, in the next stage of your growth, if everything's going well, you've got these customers, paying customers signing up for your technology, this is where you'll also raise large VC rounds. And almost every VC fund in India is also sort of incorporated outside India in terms of the actual fund entity. So they don't have any restrictions. I'm asked this question quite a lot, so I'll just preempt it. Most of the VC funds, almost all VC funds that you sort of talk to in India, the legal entities are incorporated outside India, so they have no restrictions in investing directly into the Delaware Corp. I would actually argue that they would actually, when you talk to a VC firm, is there any VC investor in this group, especially an Indian fund? Okay. When you talk to them about an investment in India Private Limited, you'll get a valuation of 1 crore, 2 crore, 3 crores. You dress it up and you start working with some of these customers, same guys, 3 million, 4 million, 5 million. That's, from a practical perspective, how different how important the structure could be in terms of how you present it. One of the things that you have to consider. Very important to note, as I mentioned, your founder stock will be here. So although you are employed in the India company, you would have stock directly in the US company. Your employees will also be employed here, but they'll be part of the option plan in the US. And as long as the India company is a subsidiary of the US company, employees in India should be able to get, and we'll talk about the specifics of the option plan in India, but employees of the India company will be able to get stock or options in the global plan in the US. I'm also often asked the question of why they shouldn't get options in the India company. The short answer is it'll be foolish, because again, there's nothing happening in the India company. When you sell the business, this is the entity that will be sold, so your employees will get liquidity because they'll be selling shares in the C Corp.
Would they be invoiced in dollars, and the payment is going to the US company then coming to India, or how does it work?
Right, so as I mentioned, there'll be a services agreement where the US company is hiring the India company to perform services. All the IP developed here is owned in the US. The US company will then provide or pay for the services on a monthly, quarterly, depending on how your accountant does it, right? So all the IP sitting here. So all your customers will be signing directly with the US company and paying in US dollars. Now, if you have India-based customers that can't do that, local banks, regional banks, or India-based, Indian sort of finance banks, or universities, or for whatever reason, agencies that have received funding from India and have restrictions in their charter documents, then what you'll need to also do, and we do this very often, and it's all sort of, KPMGs and ENYs have spent 6 months cycling around and approved all of this, is that there'll be a license of the technology from US to India. So India company will basically become a reseller of the US corporation and sell to the customers in India, and then also owe the service fees back to the US company. So that would be the structure if there is a customer that for whatever reasons is not able to work directly with the US company.
So the question, company entire revenue is recognized by the Indian company, is being taxed and all clean. In that case, what's the mechanism?
You really want us to...
Given that in 2 years everything happened in the India company, the US is just there.
So if it's from day one, let's say you structure this, but all your customers are in India, you can still do it. The customers can still either sign up directly to the US, which is where all the IP is, or if they have concerns then, or payment issues, in terms of paying in dollars, then you could set up a license for sale to India customers. Now, keep in mind, this is not an ideal structure where your customers will always be India. If you're going to be a shadi.com, this may not be the best structure. I'm talking about where your customers are likely to be initially in India, but grow outside India, right? So that's where we're looking at. So for the initial customers, you can structure a license for India and sell in India. But the plan would be, and the expectation would be, that the customer will actually grow outside India, which is where all the IP and all of the revenues will be concentrated. Yes? Sharda, you had something?
Or the simple thing, India entity will, so the India, but when you want to flip, because now you are showcasing value in India, and the valuation when you flip the structure to the holding to the US will be a lot more taxes that you pay, because the pricing of the India entity, the value of India entity, which now gets moved to the US, is the tax issue again. So you pay more taxes then. So fair market value. And there are different ways of doing the pricing. So it's, you can do it, it's just that you pay tax.
Let's just take, as we are, and future customers in the US will currently just maintain status quo, don't do fundraising again, and then
again, you'll be paying more taxes.
I'm not making it personal about you at all. I'm just saying, generally speaking, you're at a point where you have some customers, hopefully you're still making losses, or you have some profits. You have revenues, but may not be profitable or may not be significantly profitable. And in any case, you haven't raised outright funding, if that's the case. Again, this is your structure you should be thinking about. Kicking the can down the line will only make it worse. The more money you raise, as Sharda mentioned, the higher the valuation of the India company. Then you have to transfer the shares that you hold as a founder in the India company. Those shares will then be valued at the point of the investment, not at the point of your revenues today. So you're making it worse for yourself. And I can promise you, based on what you're just describing, if you don't do it today, 2 years later you'll be calling me and asking me to do this, and it'll be 6 times, it'll take 6 months and 3 or 4 times more expensive. So that's, and that's one of the reasons I do this, is because I've worked with over 4 or 5 years ago, in the last 4 or 5 years, I've worked with companies that were in similar situations, and they, for various reasons, either got some advice or decided that they have some sort of low-hanging fruit, they have 100-200,000 from friends or some small angel fund, they close on that. 2 years later they want to do it, and because then they realize that they're stagnating, they can't raise the second round of funding, or their customers are all going to be, or mostly outside of India, then they get stuck. So you and I will either have a discussion tomorrow or we'll have it in 2 years, and you can decide how painful you want it to be, really. Yeah, good question. You don't have to be, so the question in the US, there are some RBI regulations. So if you have money sitting in the US, if you had ever worked in the US and you have $100 that you had earned and at least $100, and not in the US, outside India, it makes it easier for the India founders to buy shares in the US company, because there's some restrictions that if you send money from India to US, which you can, then there's some restrictions the US company having a subsidiary in India. So we would always recommend that either you use money sitting outside US that you may have earned when you were in the US or outside India, or if you don't have that, then have some friends or relatives buy the shares and then gift those to you, and we can talk about that process, specific process also. But physically you don't need to be in the US to start all of this, to get to this stage. We work with, I'm meeting some of them for the first time on this trip, where they raised multiple rounds of funding. You will, at some point or the other, you will be traveling back and forth. At some point you will be visiting the customers. You will probably want to hire a bunch of people as you grow, but on day one you don't need to be. The easiest route for getting in on terms of visa is a B1, a business visa. And if you have a company, then obviously you can justify that you're going for the business of that company. If you're looking to relocate to the US, then you can look at an L1, which is the intra-company transfer, but you need to be employed by the India company for at least a year. But that's fairly straightforward also. As long as you have the structure in place, you should be able to file for an L1. But initially you don't have to be physically in the US. And then as you need to travel, you would do it on a B1, a business visa, and sort of for business meetings you would be able to do that.
Box or something like that? Or?
So you would have an $100 a year or $120 a year depending on the agent. You will need a... Go ahead.
Is it free zone kind of thing? It's called free zone on this country in the US.
Well, this is not, so there's no free, it's just Delaware is one of the states. It's actually the first state of the union, right, in US. So Delaware is just a state in US. But I was just going to say, to finish the answer, you will need a physical address. It can be a PO box, but always recommended you use some friends or someone where the mail can be checked, because the agent is not checking. The agent is just to direct your mail. So having a someone's physical address, not a PO box, is recommended.
Does it have to be in Delaware state?
No, it has to be somewhere in the US. Well, it can be actually outside US also, as long as there's... In most cases, for first 6 months, we sometimes offer to use our address, as the initial address for first 6 months. In most cases, unless there's a lawsuit or something goes horribly wrong, you'll be getting American Express credit card applications and all spam mail, which we keep throwing in junk. But you can then, when you set up a bank account, you would do it all online, so you can do all paperless as much as possible. Sorry, I've been waiting for that. This gentleman's been waiting, so very patient.
Our mid-future is Indian customer, yeah, and then you're going global, but you may or may not go to US. Still, you think this is a good structure?
Yes. If you're not going US,
may or may not.
Right. So if you want to give yourself the flexibility, then it's a good structure. If you tell me that you are never going to be in US, then I would say, then you may want to consider a tax sort of friendly jurisdiction like a Cayman Islands, BVI, Irish holding company. But even in that case, you have to be thinking about from a customer's perspective, right? Don't think about what works for you. Think about what you're presenting to a customer. Are you presenting to a customer a company that looks like that, where they're looking at doing diligence? Both customers and investors, right? When they're doing diligence, are they doing diligence in a Cayman corporation? And that will trigger a lot of alarm bells for most companies, and especially if they're US based or European based companies, because there's always internal sort of banking and all sorts of regulations. And customers, and then as you start working with investors, how would investors perceive? If you have investors, and if you know your investors are also all going to be outside US, and your customers are all going to be outside US, then it might make sense to be in Cayman or some other tax, favored jurisdiction. But other than that, even if your investors are likely to be in US, you still want to present a Delaware corporation.
What about Europe or London?
London is a good option if I can't speak to that, but London is a good option if your customers are going to be in Europe.
I came from there. As I said, mostly my customer will be in India. But maybe in 2-3 years time I will start thinking global.
Right.
So if I compare with the US, with Europe or London, UK, what's your suggestion?
No, that's what I'm saying. So don't worry about where you come from. It doesn't matter. The question is where your customers will be, where your investors will be, where your likely sale will be. Who's likely to buy the business? Right? If it's Yahoo or Google looking to buy your business, and they have to buy a London-based or a European-based company, what are the tax issues? How they'll probably be more comfortable from an IP protection perspective than they would be in an India or Singapore-based company, but they will still have some challenges on tax and structuring. Keep in mind, if they have to buy, they're a Delaware company here, they're buying a Delaware company, it's very easy, right? When I get a call from, when I'm working with a client that's getting sold to a Google US, we talk to the general counsel's office, whoever's the lead lawyer. When we talk about the fact that it's a Delaware company, it's a breeze. There's check, right? I mean, when they're doing diligence. If we talk about a European-based company, it'll be let's learn a little bit more about it. If we say it's an India-based company, it's like a non-starter, literally. So that's where they tell us that can we flip it into a Delaware company before we do the acquisition. So it depends, right? But again, don't worry about where you're coming from. Just because you're coming from London doesn't help. It's where the customer will be, where the investor will be, where the actual end acquirer will be.
I have a host of professional etc. that I need to do with the MCA and
Right.
ROC over here. If I were to move to this kind of a situation, for discussion, let's just start afresh. I'm looking to incorporate, I incorporate like this, versus I incorporate as an India private. What are the tax, etc. implications for the India private limited?
Sorry, but you still have to deal with the India guys, right? So exactly as you would from any other India company. But Sharda can talk about the specifics.
Mr. Anil, why they don't have plans to sell the
The US entity doesn't require any professional
Right.
tax.
See, all you're doing is
Yeah.
putting a shell on top, right? But everything else,
Maintenance perspective, it is what you're saying, there's an annual tax,
Right.
and there's a post box where you
Right.
get spam mostly,
right?
and that's about it.
Exactly right. Yeah.
But stay.
Yeah.
So in terms of where you need to be, we spoke about market ops, fundraise, which is again the valuation game, and many investors kind of push you out there as a better exit. The legal avatar that you need to think about, whether my holding in the US, sub in India, or holding in India and sub in the US, you can bill either ways based on where your customer is. And going back to Anil's previous slide where we spoke about how the funding to the India entity can happen, there are three major ways: equity, loan, or the invoicing mechanism that he was talking about. It's nice to keep the equity to the bare minimum requirement versus the invoicing mechanism, because then you just need to pay the transfer pricing requirements. A little complex. In terms of the India entity itself, where we are talking about now I have my holding in the US, I need to have the India entity, boom, you need to do everything that you have to do in India. It takes about 6 weeks, where earlier it was just certificate of incorporation, but now there are additional layers of processes that have come by, which now means you need to get a certificate of commencement of business. Takes an easy 6 weeks. Here he says, sitting in India, you can open up an entity in 1 day, and I'm talking about 6 weeks. And there are multiple kind of registrations required in order to make it operational. A PAN, a permanent account number under TAN, are compulsory. With PAN you open a bank account, that's another process. And then there are other professional tax or service tax. If you're a software product, it's both service tax and VAT. That clarity is still not come by the tax guys. There is IEC, shops and establishments, PF now perhaps with 10 people, ESI perhaps with 10 people. That is the change that may come by in maybe another 2-3 months or so, because the bill is out. So these are some of the requirements. Now, to talk about the entire structuring in US and then I have an India entity, we have a bit of a problem. Let me explain. So there are very specific ways of structuring it. Now, we don't have mechanisms of sending money out of India to the US for incorporation. However, we have specific laws, the overseas direct investment, where you can go and acquire shares. Cannot incorporate, but you can go and acquire shares.
Let me add to that. So, and that's absolutely right. And what we do to address that issue is we would actually incorporate the company. So if you called us and either we or somebody that you would have in the US, a friend or relative, they would pay the $300-$400, incorporate in their name. Then US founders sitting in India would then buy shares in the US company. So that's one way to sort of address that particular issue.
And then they gift shares to the founders.
That's right.
it's okay to own as a gift, but you cannot incorporate. So that's kind of making it a bit complex.
Then a better way to shut it down, open a US entity, and then open a new entity in India as a baby of the parent or something. Is that a recommended way, or you have some better idea?
It's actually easier when there is a seed investment that's already happened in the India entity. Then you have some metrics of valuation of the India entity. Now, for you to flip it into the US entity, we are going into flip to the US entity. Then you have the valuation of India entity. And what does India entity have? You said it's pre-revenue. So all of it is for the IP, and IP is what the holding entity should hold, which means that is the valuation for which you need to pay tax for you to flip it to the US and then have a sub. So is that one of the ways? It's one of the ways. Should you shut it down, start someone, so you go to Anil, he incorporates in the US, and then he holds it for a week or so before he gives it to the founders, and then the founders kind of bring in money in order to buy the shares perhaps, and then that money kind of comes in to acquire the shares of the India entity. One of the ways of doing it. Or if you can hold for 2 minutes, we get to the flip where we talk about the tax issues of that.
Right, sure. And I think that's a little different from your issue, which is where we may end up doing what he's suggesting.
Yeah.
So, and we'll talk about that and as part of the flip.
Have to be taken care of.
Right,
Yeah.
right. But yours is actually easier to fast forward, because if you
Yeah.
don't have valuation and revenues and all that, then you as shareholders of the India company can sell those shares directly at the 1 lakh rupees that you paid for it, and hopefully everything can be done very cleanly.
Right.
You will have a little bit more of a problem.
But if the same thing is taken over by the US, the question is, how do you connect these two Indian entities at what time for tax implications?
So, yeah, and that's our showstopper, I guess.
And yeah.
So Indian Incorporation, and then we have an agreement of service agreement, and then when we want to sell products to Indian companies, instead of the Indian company selling it, can US company and manage all the taxation issues? Can US company directly appoint third-party resellers to do that? So Indian entity is not at all paying VAT and service tax and thousands of other taxes which are required to sell a product in India.
Yes. Anybody has a reseller to sell the product in India.
So it is
but
not
Sharda
necessary that Indian company needs to do the selling.
Indian
License
company
can be given to anybody.
Absolutely right, and the Indian company can continue to be the outsource or a service provider in that model, and the US company would work with third parties without. Sharda will tell you the specifics of tax or other compliances needed by the other India company as a reseller, but there's no restriction. If I have a US company and I want to appoint an Indian company to resell my product, there's no restriction, at least from a US perspective, and I suspect from an Indian perspective.
So the multiple things that the India entity can do in this scenario, right? Going back to Anil's slide where he has the holding in the US, you have the India sub. The India sub, you don't have restrictions of India sub having a customer contract. If you have the customer contract with the India entity will raise the money, will raise the invoice, get the money in, right? Now there are two things. The money is sitting in the India entity, but the intellectual property for the sale is sitting in the US. So the contract between these two entities is a master services agreement. Could be various, a platform license agreement, a royalty agreement. It could be various of those services. The India entity will then pay back to the US for either as a platform license or royalty, etc. There is a small sum that it retains on which it pays its income tax. Can it raise customer contracts? Yes, it can.
But still on the invoice amount, they have to have service tax, VAT,
Yes.
everything. So
Yes.
we can completely ignore that, or the Indian entity might not register for service tax, or not service tax is compulsory, but for VAT and other taxes, right? And have a third company which does only reselling of the product and avoid all the compliance issues from the Indian entity. Is there any Indian legal problem in that?
There is Indian legal problem. You have to still have all of these registrations. You still are invoicing. You're raising an invoice to the US entity, which means you already have these taxes and registrations in place. So you already will be filing returns, and the compliance has to be in place. Wouldn't it be nice that the India entity, like Anil was saying, also becomes a reseller, therefore the value is generated within your group companies?
But only service tax is required, not VAT.
I think
Based on the
I think the
products that
difference
are-
is if you're working with a reseller that's already set up to be a reseller, then it's their problem, not your problem. That's really the distinction between the two models. Right.
So, what's the rating in India, and also maintaining and filing taxes and those kind of issues, logistical issues, when you have it incorporated and you don't really have anybody to help you out there, kind of thing.
Sharda will talk about the India
it's
part.
a little expensive. It's a long procedure. There are too many licenses to be obtained to make it operational. So it is a bunch of things which is specific to your business. You need to budget at least about 80,000-90,000 rupees for the India entity easily, because there are so many registrations apart from incorporation. If you go on to annual compliances, you will need a statutory audit, you will need the company secretarial practice services, etc. That will be another 80,000-90,000 rupees per annum.
And it's not just the money, right? It's a lot of your time spent on sitting outside a bank and figuring out when they can get a stamp, and then figuring out that it's the wrong stamp, and then doing it again all over
a little better.
No, absolutely not. When it comes to FCTRS, no. But also to answer your earlier question, you do help yourself if you're setting up a US and India company, because instead of just an India company from a compliance perspective, because although as Sharda said, your compliance in India as a founder and company operationally still remains the same. If you're raising investments and the investments are all outside India into the US company, you don't have to deal with a lot of crap that you would otherwise have to deal with in India taking the investment there. So your investors, including your angels, will be thankful that they're not subject to. I can tell you an angel, a very prominent angel in Silicon Valley I worked with, who invested in Redbus and still is figuring out how much of his capital gains he's willing to pay, but nobody can tell him how much needs to be withheld and what certificate he needs to file. So those are things that your investors will be thankful for, although you still have to deal with, and that's sort of where Sharda comes in helping out, setting all of that up.
I'm still seeing it as a talk, talking about having a one-day incorporation. We would love to see it happen. Hopeful.
Yeah, but there's lots of issues, right? I think that will happen because Mr. Modi has to show something, but you still have to deal with bureaucrats, you still have to do with bankers, you still have to deal with Canara Bank banker who's going to say, I haven't seen this RBI circular. You will have to deal with the RBI banker who will say, I don't even know what you're talking about, and KPMG guy who has that RBI circular that nobody understands, and you'll have to still deal with all of that stuff.
If you don't plan to raise fund in US, but you have customers in US, and if you plan to raise fund from Indian, maybe your friends or family, then this setup will work.
It will work. There are some restrictions. If you are individuals, then under the LRA scheme, there's a restriction of $125,000 a year that individuals can invest in non-India companies. So,
which is the next point,
Okay.
the LRS.
why don't you address that? Yeah.
Sure. What happens if you have the US entity but a bunch of Indians? Then we're talking about this 125,000. It's kind of gone to 75,000, back to $125,000. It can be used to acquire shares, but some of the banks interpret it as the ODI, the overseas direct investment, and there are a bunch of declarations that the individual investor will have to sign up. And what that means is he can take the money in, and that has to be the operating entity, and there are further restrictions of that entity. If this went in from India, then for it to come back becomes a round tripping of money, and there are restrictions that that money has to go and stay there for operations in that entity. You cannot bring, or you have to find different ways of bringing that money back into India. And from August 2013, that's the complication that came by. They said that has to be the operating entity and it cannot have any step-down subsidiary. So and some of the banks have kind of interpreted that in in a very difficult way, where an individual, he is sending the money out. This entity in the US is considered as a wholly owned subsidiary of a individual. So legally it doesn't make sense. So what they say is then they get a declaration that that money cannot be used for a subsidiary. So there's a new regulation, August 2013, each bank interpreting it in a very different way, and we are dealing with some problems.
Right. I mean, the short answer is doable. You need to structure it carefully. You need to make sure that the initial incorporation was done properly, so it is not deemed as a Indian founders incorporating a company that now they're investing in and bringing money back, complying with the LRS, just sort of structuring it properly. In extreme cases, we've actually had our clients set up 2 bank accounts. One bank account in the US where the money coming from India would sit, and another bank account where all the outside investments will come, which is the money that's used to buy the subsidiary shares of the Indian company. So there are ways around it, and Sharda and I worked actually on transactions where we've been able to structure those also.
So as a
Okay, I think that
if you are raising some fund for the US product company, can I use the fund to the Indian operation as well?
Okay, let me see if I understood your question right. So it is the product of the India company that the US entity is acquiring?
No. Indian company has developed multiple products. Okay. Out of the 3 or 4 products, one products we want to raise as a US company. What will be the procedure for the acquisition of it?
This is a very fact-driven one.
Yeah, so you would set up a US company. If you haven't filed patents or any IP in India, or if you haven't capitalized the development of that product in your tax filings, then I would say that nobody in India really knows that that product is owned in the India company. As founders, individual founders, you would assign that into the US company directly. US company would then set up a separate subsidiary in India for that complete parallel structure, and then you could use the funding in US and have a services agreement with your existing company, where the existing company will continue to support the development and get paid from the US funding. Make sense?
Yeah.
Okay.
And the existing business after the US.
Well, so that's where we talk about the flip, and I guess we should get into it at some point. But that's where it's a very fact, and you need to be careful, because if you have customers or IP in India and you're going to suddenly take it or what's called externalize it or flip it, you want to be careful about the tax implications. And I have a simple way of doing it, which is to ignore everything you've done and start a completely new parallel structure to the extent you can. And the earlier you do, the better from your perspective again. So 2 years later, it'll be not as easy to do as it is to do today.
Will you have to postpone the funding event in India?
You have to postpone your funding event in India, absolutely, and you have to talk to and make sure your angels that are ready to invest are comfortable investing in the US company, because obviously I'm not suggesting that you not raise funding because you want to be a US company. You need to obviously have that discussion. But keep in mind, if you make that decision, then incorporating US and closing on the investment may actually be, from a time perspective, still be easier to do than doing all the other stuff that you'll have to dance around for closing the investment in the India company.
So if there were funds parked outside of India, let's say in the US, and they were used to buy out the entity right away, that might be relatively.
So let's hold that again when we get to the flip.
So suppose I don't have any funds outside of India. I've always worked in India. How do I then kind of operate that, given the new restrictions that have come in? Because specifically, I started doing this after the August 2013 thing, and I realized if I'd done that a month.
He's your man.
Yes.
He's your man. He will incorporate for you.
This is not a solicitation for clients, so I will do it or someone in the
That's why I wanted to solicit.
Yes, but I want to make sure about that, because I don't want to get in trouble at all. But yes, I mean, so we would, or someone in US would incorporate and pay for the incorporation. Whenever you get funding, sort of would get reimbursed, and it's $337 to answer the other question. If you don't have any money to buy your founder stock, then the only option is to use the LRS scheme. But in that case, as we mentioned, we'll have to take the extreme case of putting that money in a separate account, which is never sort of used to bring it into India as part of the services arrangement. So there's still a way to structure it. You can still transfer money from your India account to the US account to buy the shares.
The account is also an individual account?
No, the company account. You'll be buying shares in the company by paying share purchase price to the company. And it's less than $100. It's not a lot of money, but still needs to be transferred.
And No, so I still didn't understand. What is to be ensured that the money doesn't come back to India? How does...
So someone like Anil or Anil will incorporate the entity for you. And then you, under the LRS/ODI declaration route, send the money to the bank account that is open for the US entity. Keep that in a separate account. Or you can send more money, or if there is customer money that kind of comes in, or an investor money that kind of comes in, that's the money you use to set up the India subsidiary.
So both have to be...
To even explain it to our top, there's another trail of money that came into India.
Just leaving that $100 and nothing.
We would recommend.
Exactly. So you can show that trace. By the way, we also have a friend who runs a service business who can actually buy the shares and gift it to you. So there are ways to do it outside of the LRS, but in extreme cases you could set up a separate bank account.
Yeah, if you're starting as a this company, the India one could be a subsidiary of the previous one. Can you, without creating too many parent and...
Why don't we just go into the flip? I have a very good slide on US versus...
Sold out, or somebody acquires that company, what are the tax implications if founders are still Indian citizens?
There's a jurisdiction where you would like to pay taxes. You need to pay taxes at least in one place. You choose the jurisdiction, and in India it's capital gains tax of 20% for long term, which is 36 months and more, or it's 30% for short term capital gains, which is less than 3 years.
It's similar, very similar. So basically, most likely you would have to pay tax in US, because when you're selling, the US company may need to withhold taxes, but you will get a credit for that in your taxes that you have to pay in India for the taxes you would have paid in the US.
But that money stays in US bank account?
No, that money comes to you. Okay. The net of that will come to you in your India bank account.
In your personal bank account.
Right. As a share, you're a shareholder of a US company, you sell shares, you will give us a wire information for where to send it, us meaning whoever's represent the company in the sale, there'll be a spreadsheet. Your allocation of the money will come directly into your India account, net of the taxes that are with that. And you'll get a certificate, your CA will work on giving you a certificate which you can use to, when you file your taxes in India, to get a credit for the taxes that you would be due in India.
Oh, very quickly, I go first?
Sure, absolutely.
So let's look at a scenario where India holding flipped to subsidiary. So the holding entity is now a subsidiary, which means we have another holding company, perhaps in the US. I'll take the US as the example, and you need to convert the India sub as a subsidiary. How does it work? You create the US entity first, and then there is a FDI that happens from the US entity into India. We spoke about the mechanisms of how the money goes there and then comes back. So the FDI can come in. It can be infusion of fresh funds into the India entity, or you dilute the shareholding of whoever is in India to lesser than 50%. Therefore, it becomes a 49%, 51% held by the US entity. Or you could transfer shares. So the India entity shareholders, presuming it's just the founders, transfer the shares to the new US entity. Okay? When that transfer happens, a lot of components need to be taken into consideration. The IP created, perhaps there is, if at all there is an investor already in the India entity, which means there is a precedent of a valuation set, and if there are customers already in India, the revenues that are there in the India entity. Now you have a value in the India entity. Now when we need to flip this, and this becomes the US becomes the holding and India is the sub, there is a valuation happens of the India entity for which you need to pay taxes, right? And I'm making it very simple, but there are a lot of ways on how the flip can happen. The easiest are listed here, but the restructuring, say a Flipkart becoming a non-India entity, or a Snapdeal becoming a non-India entity, has its own nuances. I have a slide for it, but it's very complex.
Let me just add my flavor on that. I guess October end 2014, I talked to a company last year, similar situation. They said, oh, we have Bloom investing, right, to invest. So we're not going to do a US company. And now we're talking October 2014, and last 6 months we've been working on getting them to reincorporate into a US company. So that's how complex, that's how easy it could have been in October 2013, and how complex it is because they took the initial investment in the India company, and now we have to figure out how to reincorporate all of that into the US.
And the other one that Anil and I are working is, we said, okay, shut down the India entity, open a new one. They opened, but then the money came in from someone else, and the shares were allotted to the Indian founder. So from optics perspective, we are going for a Series A. The optics perspective is the India guys send the money out because they are the shareholders. So now Anil and I are working on that particular transaction of cleaning the whole thing up. So it's
and neither of us were involved in the original structure.
Yeah. and there's very specific way of doing the structuring, and very specific sequencing as well.
And not to scare anybody, I mean, it's all doable, it's all things that, the point really I want to emphasize it, the earlier you decide to do it, the better for everybody, the less painful for everybody.
The simple thing to that is that if you're doing it out of your budget, that creation would be, so that you feel more confident in doing it ourselves and earlier.
So if you're looking to set up a US, now that you've decided that it's going to be a US incorporated company, you've seen the light and you want to start there, you need $300-400 to incorporate, make the filing fees. There's some legal expenses, and I can't talk publicly, but it's not huge numbers, a few $1,000s at the most to get that up and running. And then you'll have to incorporate the company in India as a subsidiary, and as Sharda said, you have to deal with the India part in any case, right? So as you would if you were starting an India company.
Private limited already. Now I have a private limited already in India.
Okay.
How do I adopt this?
Yeah, so as long as you haven't raised money or the value hasn't gone up, you would incorporate a US company and transfer shares of the India company to the US company. Your CA will provide a valuation certificate, hopefully still 1 lakh rupees. So that's the only amount that needs to get paid. So it's fairly, at that point it's fairly straightforward.
Okay. And the costing will be pretty much the same you said in the previous one. Couple of hundreds to never, couple of thousands.
Right, for the legal part, right.
And the time to maintain the thing, what's the effort to maintain?
You have to make a filing, one online filing a year, and that's the $350 franchise fees, and you have to pay taxes or file taxes. Almost every CPA that works with startups in US will tell you that unless and until you're making revenues, profits, you don't file taxes. So you don't even need to worry about tax. If you do decide to, because you really want to comply with the law, it's at, say, you'll find accountants in US will do it for like $200-300 a month or $1,000 a year to file your taxes, so that's like the sort of cost you're looking at for, assuming that you haven't raised any outright funding, you don't have a whole lot of revenues. Once you have funding and revenues, then thankfully, legal fees go up, and that's where we make money, but accounting fees, maintenance fees goes up, but that's where it's a good problem to have, right? But until that time, it's fairly straightforward and not expensive.
I hope you have another slide on the flip.
I don't know, and we'll go with this.
All right. Now, how do we do when the India subsidiary is flipped to the holding? So you thought US is the market. You thought you would raise money in the US. You thought, oh, I'm a SaaS company, and therefore, if I am looked upon as a US entity, I can do 1,000 rupees per user versus 200 rupees per user. But none of it worked. So now you want, and what you found during the journey is there are a lot more India customers, India investors into the entity, and therefore you now want to be the India holding entity, because that becomes the new value creating entity. Now you want to flip it the other way. A little easier. The ODI, the overseas direct investments, are a lot more stringent than foreign direct investments. So money coming in is a lot more easier compared to money moving out of India. So that in terms of declarations to valuations, everything is very, very different. So to give you an example, when there is foreign direct investment coming into India, you do a projections of the India entity for the 5 years, and you arrive at something called discount free cash flow method, the DCF method. The money that comes in has to be above that price, and it's easy to claim anything above the price. Whereas when money goes out of India, you do the same valuation on a DCF method, but it has to be below or equal to the DCF method, which is where the difficulty comes in. And that's the reason why most investors would like to have the entity outside of India, because sending money out from India is very difficult. We have this.
And this is a 5-year just projection, right?
Something you prepare, your CA has to do that part, right?
Yeah.
Not you, yeah.
Yeah, and the CAs ask you how much do you want it to be?
Right. But they still have to stamp it.
Organizations. So. And then you have this new guideline of joint venture or a wholly owned subsidiary, which still becomes easier. There are tax implications. Again, the whole modus operandi of transfer of IP and assets into the India entity, because this is now the value creating entity, and taxes when you transfer that. I think you have to pay the taxes in the US for it. So there will be tax considerations. And very, very quickly, when I say it is complex, it can get as complex as this. There are multiple ways when these restructuring can happen. It could be through divestitures, it could be JVs, acquisitions, M&A. So if a Flipkart wants to become a non-India entity, it has an entity outside, and then does it acquire here or does it do an asset, etc. Various ways of the restructuring that happens. So we took the first two simpler ones because it's kind of easier at the startup stage.
Right, I agree. I think, but again, this is not to scare you. This is the worst case scenario. It's if you start from day one, or if you haven't raised a lot of money, if you haven't really signed up a whole bunch of customers, revenues, or been foolish enough to file IP patents in India. It's fairly straightforward to get to that structure. Should we keep going, or any questions? I guess now that we're talking about flip, everybody's silent, which is great. I guess we covered everything.
The founder, the shareholder, and I want to open a Delaware firm, and would like to, be a shareholder there as well. So the management of the Indian company and the directors, who are also the shareholders, will also be the director and shareholders of the Delaware company. So, how to structure that? Is there some complications coming in because of that? Well, if the major shareholders in both the companies are same and are also the directors, so they are the management as well as the shareholders in both the companies. So, are there any complications?
Delaware law, most US jurisdictions don't require you to be a resident to be an officer or director of that company. You can't be in the US and doing work for the company unless you have a valid work visa. But you can be sitting in India and being an officer and performing services and be a director of the US company. So there's no complication from that perspective. There is, in India, there's sometimes prosecution, and it wouldn't happen at the early stage. It happens when you become a Flipkart or a Snapdeal, where Indian authorities would claim that because all the management decision making of the US company is based in India, the US company is really a India company or a permanent establishment of an India company, so they will tax the US company in India. So you want to be very careful that at that much before the time you get to a stage where you've raised millions of dollars, you have all global customers, you want to have sort of management shift, have some director outside India, some management decision making resident outside India into the US company. But initially, when you're starting up, it's not an issue.
So what would be the good framework that for the Indian holding, I set up a new management, and the Delaware company is where the founders sit.
Keep in mind the India company at that point is 100% subsidiary of the US.
Yes.
So there's nothing going on in India other than employment and compliances, right? So
there is just one transfer pricing based related party disclosures that you would do in the accounts, and the India entity will perhaps or at the US level a consolidated accounts that you give. So it's disclosures and not complex. But if you do not have that holding sub relationship established, then we have issues. because subsidiary is not just by equity, subsidiary is also substantial board or management in both the entities. So you get established as a subsidiary, not through equity, but some other mechanisms, then again you get into disclosure. So it's better to have that stronger relationship of a holding and sub through equity, so it then becomes easier for compliance perspective.
Right, and we should talk about transfer pricing. If it's affiliated entities, which the US parent India company will be, the Indian sub will be, the services arrangement should be in compliance with transfer pricing, which sounds very complicated, but it's a services agreement where you have your CA plug-in, a service fee markup for the service to be provided by India, which is the markup is really the profit that is subject to tax in India. So it should be substantial, and the CA will tell you what that percentage is.
Anil, one quick question. You said US.
I do.
If you do have it, can you quickly briefly go through it, because we already have a company incorporated in Singapore. So if you can just take a couple of minutes to share any pros and cons.
Sure. Sure. So I guess
that the incorporation process can. So if I'm a single founder, do I need to and I'm starting up right now, do I need to do the incorporation in day 0 or day 1, or can I delay it to the point when I have some visibility into investment?
Sort of my perspective, and Sharda may or may not agree. Firstly, if we talked about the founders, prenup agreements and all that stuff, right? So I would suggest that at any time that you have a third party, including a co-founder, you should incorporate, and even without, less worried about the founders agreement and more worried about incorporating and having an agreement between the company and each of you directly with the company. So my bright line test is, if you're working with any third party, if you're sitting at home cranking code and nothing else is happening, then you don't need to incorporate. I would suggest, hold off. But if you have third parties coming in, adding value, developing, helping on the code, some uncle providing advice on business, some uncle putting some money into buying your servers, at each level you're creating complications. And I say this all the time, it's very easy to set up legal entities for startups, very, very easy to set them up properly. Very difficult to undo something that you haven't done properly. So just keep that perspective in mind. So until the point you have a third party helping you, you're hiring people or raising money, you're probably better off. The only caveat to that is, if you're raising money from a US, and I'll just talk about US and then Sharda can add from India, I think it's similar. But the example I gave is, when you start a company, you'll get, initially you will have 100% of the equity and you will buy it for $100. In a Delaware company, you will buy your 10 million shares for $100. You can do that on day one because the value of those shares is really $100. That's the money you're putting in. If you wait until you get a term sheet, and let's say you get an investor putting in, just to simplify numbers, $5 million at 10 million valuation. At that time you say, wait a minute, so I have to give up 50% of the company to the investor. Hey Anil, let's set up a company and have the company issue me shares. Guess what? Those shares at that time are now valued at $5 million. Yeah. So you either pay $5 million or you pay tax on $5 million worth of shares, which you could have avoided by buying those shares at $100 on day one, much before the financing. So that's the other advantage of incorporating early now.
Anil, I have a question. Let's say I have a company US versus India identity.
It can be 5149.
It can be that one, because I'm starting a company and I'm a US citizen, they're working here. So the plan is probably if we want to go global, so one guy move there and then we can have 50% or it has to be 100%.
Yeah, the question is
now you say free application or whatever, right? So we don't know either we are generating the money or not. So once we establish the platform, there are the additional services which will be introduced, which will make the money. But we don't know about the market, either the platform will get popular and all that, right?
So we're talking about two different things, right? One is the ownership.
Yeah.
So I don't think what you said is anything to do with the ownership. I would suggest even in that you have, the question is who owns the IP and where the business will be and where sort of their customers and growth will be, which is unrelated to ownership of the shares of that company.
We will start in India because the market is Indian. We don't see any market probably next 10 years in US, right?
Right.
But let's say down the line 5 years, we see the market in US, and one of us, probably me, I moved to US and we found a US Delaware company. So it may be 50% in stock of Indian company, right? We set up the US Delaware everything. and then Indian subsidiary will be 50%, not the 100% stock. Can we do that one? And we are not making any money in the next 5 years.
Right. No, that's good. From my perspective. But keep. So all I'm saying is, then you're still not solving the. I guess you haven't answered the question of what are you doing, right? I mean, if you want to be an India company because your customers in India, then be an India company. If you give yourself the flexibility, then there's no reason for the US company not to hold 100% of the India company. You will have to, what Sharda said in flip 2, you'll have to reflip into an India holding company in any case. So whether the India company, Indian residents hold 49% or US company holds 100%, the reflip will have to happen in the future in any case.
Okay.
Right.
Some time back you spoke about patents. Indian residents right now, we still have to go to the local patenting authority before we can file the US. So now, and were you talking about assigning the patent to the US entity, or what is it? Because right now we are in process of patenting, which is in the individual founders' names, not assigned to the company. So would that make it more complicated or simpler?
Right. And we have to preempt that. Let's talk about the point I was making is, as employees of the India entity, you would assign all the work you're doing to the India entity. As part of the services agreement, the India entity would assign all the work to the US company. The US company owning that technology will file for patents in the US. If you're sitting in India and creating that, you may need a US, India PTO sort of permission to do that filing, and Gosakan will talk about that. But maybe, and we want to keep the last half an hour for patents, all the good stuff on patents. So we want to just go through the Singapore stuff, and it seems like there's a few other questions on that.
One very quick question. Would US company holds 100% of the India entity? Would that be optimal?
Yes.
Delaware C?
Yes, one. Yes.
Founders agreement is a very US thing, and if you have a third party and you want to involve him with some kind of agreement in India, if it's a private limited, you need an agreement between a company and a third party, not between the founders. Is it correct?
In the US also, you would have an agreement with the founder and the company itself. Once you've incorporated the company, what we talked about is pre-incorporation. If you two guys are starting a company and haven't really got to a stage of incorporated company, how they sort of agree on how to divvy up equity. But once you've incorporated, the US company will issue you shares as a founder, and you will sign up to the vesting, acceleration, all the conditions directly with the US company.
Yeah. So if after being a solo founder, starting my private limited, I've got a third party, the right thing to do is not a co-founder agreement, but an agreement between the company and this third party.
Right. So that third party will become, are they resident in India or US?
It's a guy based in India only.
Yeah. So then they would be an employee of or a consultant to the India company, and assign all the work. The key is to make sure they're assigning all the work, all the advice, all the code development to the India company as an employee or consultant to the India company.
And then probably getting as in stake of the...
right. And they'll buy shares in the US company directly.
Yeah.
That's right.
No, for now only India, but it's an employee or a consultant agreement of sorts between the company where stakes could be involved, which can make him co-founder, something like that.
Right.
Perfect.
But the key is that all the shareholding will be consolidated in the US.
Yeah.
All the IP or development will be assigned to India and then through the India company.
There's no US company, no? It's a private limited in India. So I'm saying, it's a specific problem I'm facing. So private limited here in India want to make it US, which we got the flip logic. Parallelly, there's a potential co-founder working on the product along with me to have an agreement. Now he has to have an agreement with the Indian company which is currently existing, or with the US company.
US company. So you would on day one or day two now, I guess, now that you have an Indian company, you would incorporate a US company. You and he will have an agreement directly with the US company, buy your shares, have conditions on the vesting. But you and he both, given that you're resident in India, would also be employees of the India company. So you have two roles, right? One is the work you're doing, and the other is the share ownership, which is consolidated in the US company.
Okay, and two agreements there.
Yeah.
All right.
Yes, we'll have to listen.
I understand.
Right.
Generally,
it depends on how screwed up it is. How, whether you've raised money and you have 20 customers and a bank and IIT, and then 2 months later IIT says, in real situations, IIT says, oh, by the way, we can't get shares in the US company, so let's not do it. Or your angel says, by the way, we've raised money from India investors, so we can't hold shares in the US company. Those are sort of things, threshold issues that we would look at. If you're starting and you haven't done a whole lot of it, you haven't filed patents, you haven't created technology, it's relatively easy. if you're on the other side, as I mentioned, I'm working with a company that we started last year, 6 months ago, that should have done it last year, which would have been a few $1,000s. Now they're doing it, and it's not my charge actually. My work and fees remain fairly consistent. It's the KPMGs and everybody else. Hopefully there's no one from KPMG here, but it's the, let's say, E&Y, and not to hold, it's the accounting and all the India regulatory stuff that you'll have to dance around. So that will take time and money to sort out. So on the US side, when you hire me, I'm looking at a US company like as if you were coming into my office starting a new US company. We help, and we are dangerous enough, to know what we have to do. But your India advisors are the ones that will charge and sort of have you do all the work, depending on how messed up it is in India.
Thank you.
Yeah.
A quick time check. We have another topic and we have another speaker.
And I'd like to sell my technology products outside the country. So what are the complications with that?
It's an India game. So you have the India entity which will be customers in the US, and the money kind of comes into the bank account. You pay the local taxes. So
there are no complications.
There aren't.
What is the product? Can you talk about, when you say selling product, that's such a broad generalization.
It's an education technology product. It's an app creation platform.
But how do you sell it? Is it a SaaS? I mean, do you use it online? Or?
Yes, it's a SaaS.
So a couple of things, right? I mean, your US customer will assume that because is it a .com or they'll assume you're a US company, and that could be misleading because you're an India company. You should disclose that, once they look at the website and figure out that it's based in IP, they could potentially have concerns about IP ownership. They will require, you'll have terms of use, privacy policy, various sort of, and these are all legal contracts. And because you're an India company, this is all now governed by Indian laws. That could raise some questions on how they would enforce any, if for example, the product that they're buying from you and that there's a third-party infringement, if they were my client, I would say, let's be careful about getting some sort of physical relationship or ownership in the US assets that we can go up against, because who's going to enforce anything that goes wrong in India relating to the IP ownership. So again, ownership of IP being outside the US will help you will realize, in working with customers and possibly getting more, sort of being able to, as Sharda was saying, instead of $200, charging $1,000, for the same underlying technology. Should we do the India, Singapore, or should we want to do the ESOP, or should we do okay.
Singapore? Okay.
How do I get out of this? Question really is, I'm beginning to get questions on why not Singapore. Singapore is a great city, country, whatever you want to call it. I still have to figure that out. And I'll tell you, the short answer is it's foolish. It's just foolish to be in Singapore. Unless, as I said, you're a Flipkart or a Shadi.com and your business is so driven by India or Asia Pacific and you're not looking to set up a global company. I touched upon it earlier. Each and every company that you aspire to be, the Facebook, Google, Intel, Apple, they're all Delaware companies, and I can assure you when they started, Singapore still existed and they still had the option of being in Singapore. They had access to really good tax and legal advisors, and they still decide to be in Singapore, in Delaware. So that's the short answer. You want to really, when you start a company, you don't start a company because you're going to save taxes. You start a company because you're going to grow it into a large company and work with large companies. So where are the customers, right? And so you have to go through some analysis of where are your customers going to be. If all your customers are Asia Pacific and India and South Asia and rest of Asia, sure, consider Singapore. Even in that case, I would argue US there's no downside to it, but sure, consider Singapore. Other than that, you're going the wrong direction. If you're working with US customers, European customers, you're a technology company, they will still sign up and sort of be more comfortable with working with IP held in a Delaware company than in a Singapore company. I can tell you most companies, I work in Silicon Valley, very fortunate to be there. Within 20 miles of where I am, we have the world's largest companies, right? The Apples, the Facebooks, the Googles, I can keep naming, Intel, Cisco, Oracles. Those guys, it's a small group of lawyers, it's a small group of tax guys, it's a small group of founders. They talk to each other and they don't know where Singapore is, and they don't care. They don't care where India is, and they don't know where India is, and they don't care. From a structural perspective, obviously, geographically they know, and all of them love coming to India and giving speeches and meeting the Prime Minister. But from a structural perspective, they're not comfortable, they don't understand laws. And when I get a call from the counsel at Facebook looking to acquire a company in India, their first question is, how do we do this, right? And can you help? When I get a call from a founder, one of the counsel at Facebook acquiring a company in Silicon Valley, a Delaware company, that's not the question. The question is, where is the diligence? Can you put it on Dropbox and let's get started? So you're sort of making it still difficult for yourself to sell either to customers or to flip forward to in the event of a sale of the business itself. If you're starting a Singapore company, you're still not solving the problem. You're still the same point. The second question I asked everybody that talks about Singapore is, name the last Singapore company that got sold for $100 million or more. Again, a technology company, real estate, all of those companies are great. Nobody knows, nobody can name it. Name the last Singapore-based company that had an IPO of $100 million or more. I will name you one Silicon Valley company, Delaware company that does that every week. So that's my answer of why you want to be in US and Delaware and not Singapore. Where are the key hires? If you're looking to hire people, especially in the Valley, and you go out, and we'll talk about that, you go out and say we're going to give you options in an India company or a Singapore company, I'll tell you, they'll walk away, because they don't understand it, they don't know what the implications are, and they'll not value it the same as getting options, a simple sort of common stock or options to buy shares in a Delaware company. So you're again, prohibiting or putting barriers for your ability to grow by hiring the key, employees. As you start working with customers or you need to raise the next round of funding, when you go to investors, your investors are likely to be in US. Almost every large VC firm in India is also set up outside India from the legal entity that's investing. So they're comfortable investing in US. They're also increasingly comfortable investing in Singapore, but for the right reasons, where the business and the sort of exit and the growth is in Singapore or Asia Pacific, they would very likely ask you to be in Singapore. But other than that, US is where you need to be.
If I also think it's a India versus Singapore kind of a.
If it's in India versus Singapore, I would say change the question to India versus US. I mean, I don't understand where Singapore has come from, other than I can tell you I'm not going to name KPMG or EY, but 4 years ago, KPMG and EY and some prominent legal firms set up offices in Singapore. And 4 years ago, everyone started talking about setting up in Singapore. So I'm not suggesting there's any correlation. It's just, I don't understand the question. What are we doing in Singapore, right? So why India and Singapore? If you are going to be, if you've seen the light and you realize that it should be a non-India company from a holding company perspective, then there is no question about India and Singapore. There's a question of India and US, and the answer is again US. And again, I'm very biased. I'm openly biased about it. I'm biased because that's what I practice. That's where I've also seen a lot of success. I've also seen Indian companies, and in the last 4 or 5 years, I've seen companies and founders that have struggled through the issues, and after seeing the light, reincorporated and grown very fast. So that's my perspective. I'll give you a live example of a Singapore-based company that I'm working with. Everyone says, the common perception in India is that Singapore is a very easy jurisdiction to do business in. It is, if you're sort of just looking for incorporating and various things. But the legal system in Singapore is as arcane as it is in India, probably worse. I'll give you 2 examples. We're working with a Singapore business because, again, the founders were advised that they should be in Singapore. And the business is primarily India. It's a media company, digital media company, business primarily India. They're now raising money from investors in the US. We've had 6 months of the US investors talking to their tax guys, talking to the Singapore lawyers, going around in circles on how all of this will work. Now we're setting up an option plan, and we have one of the top law firms in Singapore helping. And they don't understand how an option plan works in Singapore, where people sitting in India can get options, people sitting in hires in US can get options in the Singapore company. Everyone's going around in circles. So the founders are going crazy. The last time they quoted $10,000 to set up an option plan in the Singapore company. We would charge $100. It's all well established. There's no sort of magic to it if in setting up a Delaware company. We have another company that I'm working with to just give you examples to sort of nail down the issues, the points. The company and the investor, again historically, I've just got involved in trying to clean up. The company and their initial investor had agreed that there's sort of milestone-based investment, and if they don't invest the third round, then the company will have the right to restructure and repurchase some of their original shares. In US, we would do that in a 1-page or 2-page agreement, and it'll take me an hour to set that agreement and complete and move on. The investor is okay with it, the company is okay with it, the founders are okay with it. But our Singapore Council have outlined a 3-page memo on what all we need to do to get there, including getting audited financials, including getting the directors to sign a solvency certificate, because under Singapore laws, and I think it's similar in India, you cannot repurchase shares unless the company is solvent. And in order to do that, you need each director to personally sign a solvency certificate. And some of the directors sitting on the board are saying, I'm not going to take that responsibility. I don't understand the solvency in Singapore laws. Something we would have done, it would have taken an hour to repurchase shares, is now taking sort of these cycles of memos and sort of this and that. So Singapore, contrary to sort of popular belief, is not the easiest jurisdiction from a legal perspective, and the way the laws are structured. When you start working with lawyers or accountants in Singapore, you realize the kind of stuff you're getting is as complicated, and these memos that you're getting is as complicated as you would get from India. Just because the challenge, the laws, underlying laws are so antiquated. So those are my thoughts. I'm happy to be proven wrong or have a debate. Right, so if you set up in Cayman Islands, then yes, it's not. But as I said, you're not setting up a company to save taxes. You're setting up a company to grow, and your customers will still have some issues about ownership of IP. Your investor will still have issues about, I'm talking about from a US perspective, right? If you have an investor based in Dubai, and they may actually prefer investing in a Jersey company or a Cayman or a BVI company, I don't know that, right? But from a US perspective, they'll have significant concerns about investing in a Jersey company or a Cayman Island company. Now, most large companies in US also have their IP sitting outside in Jersey or Manchester Isle or Ireland. All of Google's IP is sitting outside, that they license outside of US, they're sitting outside in an Irish company. That's a good problem to have, but when you get to a stage where you have $1 billion or more of profits, and you have this technology that's going to be licensed globally, you will pay an EY or KPMG lots of money to restructure there. But that's not how Google is still a Delaware holding company. So that's where sort of the differentiation is. When you hear about these very exciting tax structures, keep in mind the underlying entity itself started and remains a Delaware company. Some of the license arrangements outside of US are structured for tax purposes in these entities. So Apple has over $1 billion sitting outside, IBM, all of these guys, and there's some obviously political debate about whether they can bring it in the US or not, but that's not relevant. What is relevant is they're all still Delaware holding companies, and for IP or license structuring, there may be other options like Jersey or other places.
I go after him now. Kind of recommend that you be present, versus I'm guessing it's about 38% in the US as taxation. There are a lot of freebies that the government of Singapore gives. Say for example, if it is a strategic advisory that they get from someone like us, right? They get a 50% discount on our bill when they present that to the international business of Singapore, some arm of Singapore government. So there are some freebies that they get, and then there are grants that the government is giving, and no taxes for 3 years if you are below $3 million Singapore dollars. So those are the ones that are attractive, and many of them, like Anil said, the last 3-4 years, it's been a jurisdiction that many of them go to. The second piece is the investors themselves. Because of the overseas direct investment where I was talking to you about how difficult it is to take the money out, they would like to have the holding in the in Singapore, and then the investment kind of flows into India. Therefore, the exit becomes easier for them. So that's the main idea. But thanks to the new Vodafone case or the Shell case that you might be following, the tax that they had to pay on an exit, the capital gains tax that they had to pay on an exit, the investor had to pay on exit. Now, if the underlying asset is India, then like any other country in this world trying to get as much tax paid in their own countries, India also kind of went and taxed Vodafone and Shell in India. So that was another reason why investors prefer to have it in Singapore, but that kind of got changed and they're still okay to have it in India. But if it's an argument between US and Singapore, I think he's kind of covered it all.
Right, no, I agree. I think so. I mean, I guess to take back what I said a little bit, India and Singapore, certainly, you know, Singapore, if you're going to be an Asia Pacific company, why be in India and be in Singapore? There are all these great incentives. But in my mind, that shouldn't even be the question. The question should be, unless you're sure that you are a Shadi.com or a Flipkart where the business is all located in India or around India, you have to be really sort of clear that you're going to be a Delaware or a US corporation. The short of it, I think also, I mean, keep in mind on the tax side, if you're a India founder, as I mentioned earlier, and you start a Singapore company, you don't save any taxes. Otherwise, Mukesh Ambani would be setting up a Singapore company. You know, it's all, you're still subject to tax in India. It's only the investors that may have some benefits of investing to save some capital gains, but it seems like that may not even be an case under the India-Singapore tax treaty.
We just have another 5 minutes.
So we can talk about, so this is, we can go quickly through this. Between India and US is that it's actually not an employee stock option plan, it's an incentive stock plan, which means it can be issued to employees, advisors and consultants. My understanding is in India it's limited to employees, right, in most respects, so it's called ESOP, and Sharda will talk about the specifics. You can issue options, as I mentioned in the structure earlier. If you're a US holding company with a subsidiary, then as long as they're employees of the Indian subsidiary, you can issue options directly in the US option plan, the global plan, directly to the employees of the Indian subsidiary. For India regulatory issues, we many times advise that you do a cashless exercise so that the employees are not having to pay any money for buying the options whenever they're exercising. They will basically what's called net exercise and get X number of shares or options, deducting sort of based on the fair market value of the shares at that time. So, and that's built in almost, I mean, in our standard option plan that, as I said, we charge $100 for or less. It's all built in, so as an employee of an Indian company subsidiary, you have the option of just saying at any time if you're not exercising, based on the fair market value, you can just give a notice of exercise and get X number of shares without having to pay any cash, which is always the preferred option if you're sitting in India, because otherwise you have to go to your registered bank and fill up the forms to send $20 out for buying those shares.
And I don't have good news for you on it. So what typically prior to 1st April 2014, which is when the Companies Act 2013 became effective, we could have had our plan, we could have had our vesting schedules, and we did not have to disclose it for any statutory authority until and unless it came up as a question that the income tax guys would ask. But because of the new act, we have certain eligibility, ineligibility, the vesting schedules, all of that has become a little more prescriptive. What do I mean by that? So the eligibility is for a director, a permanent employee, and an employee of a holding or a subsidiary or an associate company. It cannot be for your consultant, it cannot be for your advisor. So you can give them shares, but not stock option. Option is not yet a share, right? The people who are not eligible for this is what the bad news is. So the promoter director or any employee who belongs to the promoter group or any director who holds more than 10% equity in the company are not eligible for ESOP. Becomes a little more complex because when we are trying to get an investor in and we are saying, okay, here's a dilution that's happening before the investment, because the investment comes in on a fully diluted basis, which means the founders are diluting, we would still say the unused grants in the option pool would go back to the founders. But but now we can't do that. So which means the dilution almost always happens from the founder's pool when an investor kind of comes in. There is a minimum 1 year that has to elapse between the grant date and the vesting date. I don't know why it's prescriptive, but it's there. But beyond 1 year, you can have your requirements of your monthly or quarterly or annual vesting schedules. It needs a board and a shareholder approval, and the exercise price has to be determined by the registered valuer. The registered valuer is still not notified, so we still go with the chartered accountant with 10 years of experience, because that's one of the category that is a defined term. And since we cannot determine the exercise price over the 4-year or a 5-year or 6-year period, what we say is the formula of how the exercise price would work. And that's something that you have to determine upfront when the ESOP scheme is getting approved by the board and the shareholders. The terms can be varied. Earlier it was very easy to kind of modify the terms, but now the terms can be varied only if it is not prejudicial to the employees. And tax is a dampener because when there is an exercise that happens, assume it is a cashless exercise by the employee, then the fair market value to that zero price that the employee is using for exercise, the difference is getting taxed as perquisite taxation. The employee is still not seeing value, as in he's not yet gotten money in his hands, but he has to pay tax. So he's kind of not very happy with that situation.
Sharda, one quick question. Would that be the case if you have an employee exercising in a US option plan as well?
Yes. And the price that employee paid tax, assume it is 100 rupees, and when he sells beyond 100 rupees, so for the difference beyond 100 is the capital gains tax that he has to pay. Now this is what happens in real scenario. The employee would like to wait till he sees some value for him to exercise, and if he is waiting for that and there is an acquisition that kind of comes in, which is what happened in Just Dial where they went public, so that is when the employees kind of exercised, we got the new changes in the Finance Act, the Budget 2014-13, where they said it has to be held for 3 years when it can be construed as a long term. So now all the Just Dial employees now wanted to backdate, which is not possible. So those are some of the considerations that you'll have to keep in mind when most likely it is the founders who spin a story on why equity, why ESOP, and the value that it creates for the employee. If you are asking what happened in Redbus, let me quickly add. No, I'm not the attorney for Redbus. It was a case of accelerated vesting, which was absent as a clause in the ESOP scheme, where they said, okay, if there is an acquisition that happens, then the vesting schedule kind of goes away, and it's considered that all options granted to the employee gets considered as vested, and therefore can be exercised as a share, and therefore they get the benefit when the acquisition happens. But one of the nice article that I was reading is, it doesn't happen in a Yahoo or any other large organization, so why beat up Redbus on it is another counter argument. So that's on the ESOP. I really wanted to keep some time for Gosakan to be talking about patents before, and then we move on to the a free flow discussion on any question that you have. Yeah? Sure, go on. So you set aside an option pool. So in your capital table, you have ESOP, and perhaps you keep it as a 10%. There are two ways of getting into ESOP. The scientific way of saying, okay, I'm going to give it to everybody in the organization, to all of these ranks, and therefore the total I need is X options, and therefore it dilutes me like 22%. You wouldn't want it. Or you would determine that I want a 10%, and therefore you distribute that 10% across. That sits in your capital table as a notional percentage in your capital table, because when the investor kind of comes in, he wants to have that 25-30%, whatever he wants, after the ESOP pool is created for a 10%. So in terms of actual voting rights, this 10% is not there because it's not at a share, if that was your question. So what we used to say, options at the time of an exit, then we used to say the founders are eligible for it. But now we can't because the promoter category is not eligible for options.
But in terms of dilution, keep in mind, you can score for $100 and you had 90 shares of founder stock and 10 shares of options in the pool. Then those $100 would be, the denominator would be 90, not 100, right? So you'll get a higher proportionate ownership of the $100.
Yeah, the fundamentals are of less significance if you have a US parent and a subsidiary in India, or it's still something that one has to take care of?
We do not go to the Companies Act provisions, but we go to the FDI or the ODI guidelines, which talks about ESOP. And who is eligible and where they pay taxes is the more important point than these. So the ESOP scheme will be of the US. The eligible employees are in India. Would that be a cashless exercise or a price that they pay? And how that money can go out is the question. That's it.
No, maybe I don't get these things very easily. So I'm saying a very basic question is that if you have a US structure and most of your stuff you're doing out of US, right? And you have an Indian subsidiary for namesake or whatever, so you're doing business. So all essentially what I think you should be doing, tell me if it is right or wrong, is filing taxes. Is there something beyond that the Indian system expects you to do, like these formalities?
It's taxes. It's just the perquisite tax that...
This becomes relevant.
Yeah.
This is still relevant, right? So you have to think about at the time of exercise, employees in India who still have to pay taxes based on prerequisite or perquisite, I guess.
Perquisite.
Perquisite. Maybe so. Whose responsibility is it to pay this tax? Is it the employee or the withholding for the company?
It's the withholding for the company.
So the Indian company has
Yes.
So the short answer is you don't have to worry about all of this, I assume, right?
Yeah.
And then you just need to worry about
the tax part.
Great. Thanks.
Either as the board administered ESOP scheme or it is ESOP trust. So if it is ESOP trust which administered, then you have to have an ESOP trust registered, and then there is an allotment that happens from the company to the trust, and then the trust kind of gives out the grant letters to the employees. It's one level more of an entity, if you will. Trust is not an entity to manage ESOP.
Somebody joins full time and you want to give him some extra share. So this will be an issue for them.
Do you want to issue shares or do you want to issue stock options?
Shares.
So it doesn't get into the stock options. So it's a direct allocation from the capital table to that employee.
But in that case, capital, you will have to pay taxes.
You can, so if it is he paying money to acquire the shares, it isn't. But if you are just granting it as sweat equity, I have another set of complete guidelines under Companies Act on how you can do sweat equity issuance. Very limited time. That come by?
The value of the shares, right? So if you're buying 100 shares or if the company is issuing you 100 shares, and I'm using US, but I assume it's the same from a tax perspective, but then in compliance. If the company is issuing 100 shares to an employee and the 100 shares are worth $100, he either pays $100 or that's an income that he has to pay tax on that, with all the regulations and compliance.
How does restricted stock do at the time of vesting?
RSUs.
So the sales you do at the time of exercise, not at the time of allocation.
If it is option, there are two tax incidents, at the time of exercise and at the time of selling.
Right, option isn't right on day one, so you have to either pay the price or pay tax. Which is why, as I was saying earlier you buy the shares at founded cost, better because you find it at the fair market value, so you're paying $100 and that's the fair market value, you don't have to pay taxes until you sell and you have capital.
How about RSU?
That RSU, I mean, that's another form of, are the RSU?
We don't have RSUs in India, so it's...
RSUs are basically units that, in most cases, public companies actually have incentives provide. It's free shares given or the right to get sort of the shares equivalent to a value associated with the company's stock price.
It doesn't come into the picture when you're doing this.
Not a struggle.
So typically, because of that, they say it's something like a phantom share. You presume that you are given 100 options. You presume that value is X today. And when you are living from X to whatever the addition is a cash component that is paid to the employee.
It can be defined later on, right? And incorporated in the AOA.
Not necessary to incorporate in the AOA. It is just a board and a shareholder approval that you would be getting, and a couple of forms that you file with the ROC, and you have the scheme that is getting approved. And in the scheme, you have all of these components and many more things that get into the approval.
So we can bring that in any time later
Yes,
on, right?
yes.
But in case if we are now an incorporated company in India, we're a private limited company, and we decide that we want to be a Delaware C Corp, and this is an integral part of
the flipping
incorporation in that.
Yes, so I guess if your question is whether you need to have an option plan in the US company, the answer is no.
Okay.
But depends on what your hiring needs are, right, at any given point. So you don't need to have it. Typically,
And
most
kind of
companies.
incorporation we don't need to have.
That's right, you don't.
We can define it any time later.
That's right. That's right.
Creating entity, then employees would like to have options of the US entity versus the India entity.
It depends, right? What
flip to patents. So it's a little bit of a different topic, and I know a bit of a transition. But what I have compiled here is a set of questions which we've been repeatedly asked for the past 10 years from inventors, primarily startups. The typical questions they ask, and how we address them. So I will give a very brief introduction. I just have 5 slides, and I'll give a very brief introduction on the process and the typical issues that have been raised. The first one is, how do we go through the patent life cycle? I'm not talking about the value of the patents and that subject. I think that's something which everybody here understands. So I'm just going through the mechanics of doing this and the issues involved. The first one is, you're a startup and you want to file a patent and protect your intellectual property. The first thing is, okay, now where do I protect myself? Where do I file a patent? It's an expensive process. Is it expensive? Which countries do I go to? The first thing you need to understand is, what's my target market? And you start off from there. So if you're filing a software product patent or a hardware patent, you first start off, the whole thought process should start with, where's my customer? You fix that geographical location. So if it's India, or if it's the US, or if it's Europe, that pretty much dictates your domain and the nature in which you file your patent application, the way you draft your patent application. For example, if it's in the US, then software patents are actually amenable. If it's in India, you would be very focused on bringing out a technical effect in it. So that's the geographical fixation. Once we fix the geographical part, next we go on to the preparing the disclosure and working with your patent firm, right? So actually there is one gate activity here, which is the patent search activity, which is actually a low cost and it says yes or no to actually move forward. And that's an activity, I think, which every one of you should engage into if you believe that you want to move forward, but you still want to test the waters. You don't know whether it's worth a patent or not. I really believe in this whole thing here. The first activity is the patent search is probably the most important. Okay, so once you do a patent search, you actually have a clear description of your environment, and the moment you start reading everybody else's patent, you actually know where you fit in. Okay, so now there is something I need to warn you about this. When you do a patent search, there is a black hole of about 18 months. If you file a patent, nobody sees that patent for 18 months, and you can't search it. So that same applies when you do a search. So there is a black hole. So it is not a perfect process. That's something which all of you need to realize. When you do a patent search, for the past 18 months, you have no idea what has happened, right? And the person who first files it gets a patent. First to file gets a patent. So that's a black hole, okay? The second one is the patent drafting. Now, you don't need to look at, again, when you're drafting a patent, you can have a beautiful portfolio of a dozen patents or whatnot. But in reality, based on our experience, it's not the number of patents, but just the quality of the patent. You can have one patent which is very powerful and which basically focuses on your core technology. Okay, so you need to really focus on the patent drafting when you're working with your patent firm on your claims, and ensure that you're not looking at building a huge portfolio of patents, but rather focusing on what's essential. And given the fact that out of 100 patents filed, here I'm just giving you all the facts, okay? Out of 100 patents filed, there are about 5 to 10 of them actually monetized. Okay? So as an inventor works, everything is important, right? Now you can buy some time if you're not very sure of whether it's actually going to monetize this, you're going to actually work on this, so you can file for a provisional patent, okay? Or you can keep the whole thing under wraps, okay, and try to see, ensure that it doesn't leak out. But then you have the first to file rule in many countries. So somebody files before you, you're at risk. So in my opinion, the day your idea is crystallized, protect it. Because if you're going to fight the first to file rule and you say that, listen, I've already been working with other academic institutions on this, I've already shared it with them, when, to invalidate a patent is a very expensive, and it's actually it's a big time sink for both you and your patent firm. We worked in patent invalidation. It's a huge exercise, and to avoid it, just file it day one. You can file a provisional. Okay. Then again, I have not put up another aspect here, which is the PCT application. Now, for you to buy time, patents are very region specific. So if you want to protect yourself in a certain country, you file it there. Now you don't know where you're going to sell, right? So you don't know which countries you're going to make money, then buy time. And the best way to buy time is through the Patent Cooperation Treaty. They have the PCT application. So that gives you a window of about 30 months to actually make your decision on which national phase entries that you would like to engage in. So that's another way of mitigating your risks. Because, for example, if you were to file a patent in Europe, it's much more expensive than in India and the US, and that's not something you'd want to do it on day one. So buy time. So in the whole patenting process, the patent life cycle, protect your idea day one and buy time. The reason I'm telling you to buy time is, today your technology is, but in 30 months you don't know whether you're going to use the same thing or it's going to be an upgrade, or you're going to file another continuation patent, which is the one which you actually want to implement. So buy time, right? And then the last part is let me get to the patent prosecution. Now that you filed your patent and you're up for rejections, right? Now this is something which I want to explain to you so that you all understand when you work with your patent firms. About, I would say, 60% of all the patents which you apply for are rejected. Okay. Now in the rest of the, say, 40%, I am yet to see any patent which is granted on day one by the examiner. Right? There's always some objection. So do not get discouraged. Okay. For example, for many of the patents, you would have, on an average, we've experienced about two rejections, and put it in common words, 2 rejections or objections. So, and To establish quality in patent prosecution, in many cases, you can actually directly talk with the patent examiner. Now, that's not something which your patent firm would encourage you to do, because typically the inventor goes on a tangent. So we try to bring in the conversation just on the claims and the elements of the invention, but we don't want to have a distraction. But it really helps sometimes to have the inventor talk to the inventor, if they believe that this is a tough case, they should actually get involved in the prosecution. So again, the prosecution, you might have one or two rejections, but that should not discourage you. Okay, and then the patent grant and the maintenance is just it's just a process where you get a formal grant, and every year and every third or fourth year you'll need to maintain your patent to continue it on the life cycle. Okay. Okay. All right. There's one more point here, which is on the concept of ownership of the patent. Okay, so while you're filing the patent, you need to clearly state on day one who owns the patent. If it's individual inventors, if you just file the patent as it is, the invention is owned by the inventors equally. So ownership and setting the assignment rights on day one is critical. So ensure that the assignment documents are submitted on the day of the patent application itself. The second one is where do you file? Okay, so we work with a number of companies who are geographically dispersed. They have different business units all over the world. I'll give you an example. There was one firm, Bangalore-based firm, which had a US office, which had some development center in Ireland, and the CTO is an American. He's sitting here and he's telling me, let's file this. Now, every country has a rule saying that the invention which has been developed in that country has to be filed in that country first. Very obvious rule, right? So now you have this complex situation where we don't know where the idea came from. So it's a simple rule of thumb. Where has the concept really been germinated? Where was it germinated? Where was the majority of the work done? Okay, it has nothing to do with the number of inventors, location. So there, the patent has to be filed first. For example, if you have India Development Center and most of the work has been done here, then you would file the patent here. Now, if you don't want to file the patent here, you could always ask the patent office, whichever country you are in, to let you file elsewhere. So you'll have to ask them for a permit, and that will take about a couple of weeks for them to send you a letter saying yes, you can file in other countries, and that will take you to the next phase. Okay.
So in the structure we talked about with the US company setting up an India entity with founders sitting here, what would be the ideal way to file for the patent in the US? I think that was one of the questions asked.
So the simplest thing to do is there are two ways of doing this. One is you file this in India, file the patent in India, and then within a year file it in the US abroad. Or if people have a reservation about filing it in India, which I see no reason to have, but if you do, then you can write to the Indian Patent Office saying this is my disclosure, this is what I found to file abroad. They would say yes, go ahead, and that letter would come to you and you would file abroad. So we have
assign it to the US.
Yeah, and assign it to the US. That's the most critical aspect here, is make sure the assignment is done. Wherever you're filing, irrespective, the assignment is done to the correct entity.
So even if you file in India, you can assign to US?
Yes, absolutely. Okay, another hot topic. What is patentable subject matter? Now, we give a lot of whenever we work with Indian inventors, right? It somehow seems that that they feel that this is obvious, right? This is not patentable subject matter. Based on our experience with Indian firms, it's always been that you're underestimating the capability of your of the IP of your products. So a lot of the processes a lot of the algorithms are indeed patentable provided they have an effective, a proper technical effect. Okay, so the process, components, entire systems are patentable. Okay. Now there have been two decisions lately. One was the Bilski case, where the US Patent Office basically said, listen, unless you have a proper technical effect, or you're not tying your software to a computer, it's not patentable. So you just can't have a random business idea you have in your mind and then apply for a patent. So since then, we all tied the concept or the algorithm or the process to a computer. So we'd say a computer implemented invention comprising this, this and this, or this process being done by this processor. Then very recently, the US court came and said, listen, don't act so clever, okay? You can't just say it's connected to a computer and say that it's a software patent. So they said, no, hold on. It's got to have a very strong technical effect. It has to have a very strong, that without that particular algorithm, for example, there was a certain case with a pseudo-random code, where without generating the pseudo-random code, you can't actually have that patent. You can't have that system working. So there's a very strong tie-in between your algorithm and the technical effect and the application. And in our experience, the moment you narrow down your concept to a particular application, a field, and less threaten the examiner, because the last thing the examiner wants to do is to grant an application which patents everything, right? And then they'd be in trouble, because then they're crippling novelty and innovation everywhere else. So, however, the moment you restrict it to your vertical, your industry vertical, your application, the chance of you getting a grant is much higher. Yeah, go ahead.
There's a flip side to that, is if you narrow it too much, then someone will build something similar and just show that it is not exactly infringing what you're doing in some similar vertical or something like that. But technologically is pretty much very same.
You are correct. I don't dispute it. Yes, there is a trade-off, but it is a trade-off. Okay, so we will have to work with the trade-off. So it's how narrow you want to have your claims, at the same time very broad. We'd like to make it as broad as possible so you capture as much market as possible. At the same time, you want to make it narrow enough so you get a grant of your patent. So obviously we, the inventor and the patent firm, work towards getting it as broad as possible. Okay. And the transformation machine test is, as you're developing applications, try to tie it in as much as possible to a technical effect or an end machine, which makes the chance of you getting a patent much higher. Oops. I think I pressed the wrong button here. 1 second. Okay. Yeah. These are simple best practices to follow in any firm. Okay. One is, don't disclose your concept unless you really have to, especially collaborators, right? External consultants. Unless you have an NDA signed with any of your collaborators or consultants, these are very loosely coined terms, because the moment you start working with customers, firms have a very neat engagement policy. They actually ensure that they have an NDA and everything else. But with collaborators and people, even the people who do the product development for you, ensure that you sign an NDA, and also ensure that you have an agreement signed between you and them, which tells you that all the IP which they develop, or any of the frameworks which they're developing that you're paying for, actually you own it from day one. That is very essential, because we have seen some cases where that was not implemented, and then the ownership was in question. All right. I'm kind of going back and forth, but another one recently we had significant issues with is this OSS complaints. a lot of the developers take code from the net, and they may maybe slightly modify it or use it directly. Now, if you're going to build a product with it, there might be some product infringement risks, because just because it's openly available doesn't mean that they don't have a licensing term. So you will have to actually ensure that you reduce your risk, and this will show up after you develop the product. And when you're going to another customer and the customer wants to ensure that there are no third-party risks involved, and once the auditing comes into play, then you won't be able to even release your product on time. So it's better to mitigate the risk on day one and ensure that you do either an infringement study. Now, there are two parts of this. One is an infringement study where you take your product, you do a patent search, you look at any patent which has all its elements and its single claim in your product. If that is the case, then you would want to modify your product. Obviously, you don't want to expose yourself to patent risks. The other one is when you're developing your code, ensure that you actually have another firm. There are a lot of softwares like Black Duck or Palameda, which you can actually run to ensure that the code is not infringing on open source licensed products. Okay, so I think that is all I have for now. Any questions? Yeah.
So you elaborate what it means really. I mean, some code runs on some machine. What exactly is technical effect? I mean, do I have to say this is how the machine state changes because how the code changes? I mean, how do you define technical effect?
Okay, I'll give you an example. This is geographical processing. So they have this the GPS. They wrote an algorithm which will enable a time to first fix. Okay, whereas it will analyze the information transmitted from the satellite, and it will find out where you're moving, and it will have an algorithm, and so that you're able to capture your position within a certain time. All right, it's an algorithm which determines the time to first fix. That's a pure software. Okay, now how do you bring on a technical effect? You have to tell that, listen, this is tied to a processor, right? This processor determines your position, and it gives a display to the user that they're at this particular position, and within so many seconds their position and the accuracy of their position is determined. So the technical effect is actually the display and the information to the user on where they are. Okay, and you have an algorithm which sits on a certain processor on a machine which enables it. Whereas if you just say, listen, I got this mathematical formula to determine, once you have this position and this, you get this. That's an algebraic equation, right? You can't patent an algebraic equation. But the moment you define it to a satellite and to a GPS system and something else, again, I'm kind of narrowing it down meaningfully. And it shows the technical effect which you actually use. So utility of that patent is very critical. That's why it's a utility patent.
So in effect, what you are saying is something that you have done that could be quantified as technical.
Exactly. Theoretically. No, the funny thing about the patenting system is, about I think 200 years ago, they said everything which is to be patented has already been patented. So we are still talking about it. So.
Excuse me, hello sir, in India, like typical?
Yeah, so it depends on which firm you're talking to. See, the funny thing is, filing a patent is just filling a form and mailing it. You'll know the results 3 to 5 years later. So for fulfilling a form and mailing it, you have registered people, okay, who would fill a form for you and mail it all the way from 10,000 rupees to I would say about 5 lakhs. Okay, so that's a spread.
Median?
Huh?
Median?
Median is flipping a coin. You don't know. So, but for a couple of lakhs is usually. See, the thing is, let's take what effort it goes to prepare a patent application. Then you would be able to guess what the price is. Okay, you would need to have a person with very significant industry experience. Okay, with about 4 to 5 years in the industry, typically a master's degree in telecom, for example, the prepare a telecom patent. They would need to work with the inventor, collaborate for a few weeks to get the patent search and discuss logically. And then you will have to take another 3 to 6 weeks to prepare the patent application, go back and forth with you at least 4 times, all right? And then you'd need to have another lawyer on the firm talking to you about why you want to file and answer all your questions. So how much does it cost you? Just guess. So that's it, right?
Sir, what is the state of a lot of patent litigations happen in pharmacy domain, but what about technology? I mean, you can see so many similar products in the market, for example, mobile phones, and companies like Flipkart or Snapdeal, they don't have anything that is of their own. I mean, it is more or less like Amazon or Alibaba model. So why is that there is nothing happening to them? Whereas if someone does a similar thing in the US, then there will be serious consequences.
I don't know the answer to that question. See, the thing is, Amazon or Flipkart, they are resellers. So are you talking whether they are selling counterfeit products? Is that the question?
No, the business model. Online retailing is not something which is very
see,
new.
the thing is, the online retailing as a business model is not patent protected. Okay, so the moment you go to business models, again, even today, there is a lot of this whole technical effect thing going on. We had a significant number of business method patents granted about 3 to 4 years ago, right? So even your business model has to be narrow, right? It has to be something very focused.
So I guess the question is, does Flipkart have any patents that would prohibit Snapdeal from doing, or for me to start doing?
If they had, they would have tried to enforce. However, in India, software per se, then again the thing is vague, is not patentable subject matter. So you have to bring in a technical effect. So for example, for some of our clients, we used to file these I won't say software patents. They did have a technical effect, but in the US when they file the patents, they never bothered to bring out a technical effect. Here it was multimedia communications, and we said, listen, it's connected to your audio thing, and it finally shows up as a voice as an output instead of a data file. So it depends. Now, if it's a pure business method, not in India.
Does Amazon have any patents that it could prohibit Snapdeal or Flipkart to do business?
Not really. If it is a pure business method and that is not protectable, it's not in India.
For example, in the US, I have seen cases where a simple feature like add to cart. There are lawsuits people going after those features. Those are the similar features that we use in India. Snapdeal has it, Flipkart has it, but no one has a problem with that.
Yeah, I think it's the question of, see, in India it is enforceable, but the Indian Patent Act has basically stated what is enforceable and what is not. A pure business method and a pure software without a proper technical effect is not patentable. It's not patent. You cannot protect your concept. It might be granted elsewhere. Okay, so when you try to enforce it here, but that doesn't mean that software products are not patentable. Wrong. The ones which have a technical effect are.
So I have to patent my software only if I'm intending to sell it outside India. Is that correct?
Depends on what you define as software. Okay, so that's a very abused term. So what a software is, it is just not algorithms. It's just not code. Right. If it does have, if you can tie it into a machine effectively, it is patentable in India. Then don't use the word software.
Thank you.
Okay, so you have the thing is, the reason I say this is, we have a lot of clients who do this software, hardware, co-generation, a mix of these things. Okay, the hybrids are very much patentable in India.
So what is the term you would use? Technology? Is that what you should use?
Yes, technology. Technology is the right word. That's why, in fact, I have not specifically said,
Yeah, I have a question.
Next step. Yeah, go ahead, please, after you.
Right. So, if I have a technology that now I put on my website or I release an app, can it be still patented afterwards, or is it too late?
Oh, it's gone. so don't see. There are regulations. It does allow you. If you see any patent act in any country, it tells you, listen, you could work with with academia, do research. You can do beta trials. Okay, but that's hell, right? So once your idea is out, it's a first to file act in many places. Then you're out. You had to prove yourself that this was a beta trial. And then it's already out in the market, so it's a mess. Don't do it. That 1 year thing in the act, which they state in all the acts, is something you need to avoid. Yeah.
If I talk about it in the website in my website without giving this specific software.
Yes.
Is that okay?
Yeah, absolutely. Once you filed a provisional, it gives you an opportunity to disclose. No, but make sure that the provisional, what you talk about, is actually there in the provisional. Because usually what they do is they just file a very skeletal structure. The invention develops over a year. And then the final embodiment you reveal, it's still not protected.
Yeah.
So what you say has to be there.
Yeah, so that brings to the second angle, which is in the next few months filing the main one. Now this provisional was filed with the mindset of a bit of a hybrid, if you will, for the Indian context as well as US context. So can we bring out the flavor for US final patent filing as a software and keep the Indian one as a method separate? I mean, can the final be different?
No, see, the thing is, even the US right now, thanks to the Alice decision, bring in a technical effect. Okay. So the whole world is converging there.
Yeah.
So, and the thing is, these new acts and the laws, they extend the lifetime of your patent. So, I mean, you're going to take you 4 years to get your patent granted. So, who knows what's going to happen in the next 4 years? So, don't take the risk and just bring in a technical effect as much as possible day one.
Sure.
Okay.
So,
please.
Can you patent trolls and the best practices to handle them, and what do we need to worry about?
Oh yeah, that's a sticky subject. There's nothing you can do. So, see, people are, a patent is an asset, right? So some people just hoard all the assets, take it to a big firm, and then sell it to them. And they tell the big firm, listen, if you don't buy it, I'm going to sell it to another big firm B, right? So that's how they are perceived. Now, not all patent trolls are bad. I mean, it's not good to comment upon it that way. It's a business model. Okay. Now, but be very careful about. There are a lot of people. A lot of people approach me to say, introduce me to your clients. I'll give them so much dollars. And then they can take 10% of the equity and this and that. And I usually don't encourage it because it's like you're talking to a inventor at a very gullible period when they're cash strapped, and they would take money to share the intellectual property, and it's just bad timing. So before you expose yourself to risk, understand why you're giving out your IP at a low price.
So what should you be careful while filing patents to make sure you're not attacked by a troll?
No. You're not attacked by a troll. In actuality, the people who are attacked by the trolls are the big firms, right? Because they're forced to buy. Right? So,
you will be solicited by the troll to buy your patent, so they can go after the big firm for a lot more money.
Yeah. So that's where I warned you that your valuation of your IP is it's not something you would just give off for a few $1,000s. It's much more than that.
You said first 18 months is. First 18 months will be black hole, so
yes.
We don't know. And if you look at the technology, last 2 years, 3 years, so much changes are happening. So when we are filing, we don't know if someone is already filed.
Yes, that's the answer. Yeah.
So
that's something you need to understand. That's the risk. That is the reality.
But nowhere there will be some description.
No,
other than
actually, it protects the inventor, right? So you're filing a patent today. For 18 months, we don't want that in the public domain. Right?
Okay.
It gives you time to breathe. So unfortunately, the black hole has been created to give you this benefit.
I mean, the advantage is Google comes out after 18 months they've invested $1 trillion to develop a technology, and at that time you get the patent, then they're stuck, right? Because now they have to come and negotiate with you.
Yeah, that's why first to file is critical. It's just day one.
Slightly different question. In protecting, to get a trademark registered in other countries as well, or is getting a domain name registered kind of like a cheap option of getting that similar thing done across the world?
See, we have the Madrid Protocol for international filing, okay, which we can actually implement through India itself, through the Madrid Protocol worldwide.
But I think the filing trademark has nothing to do with filing the patent. I think
Yeah, correct. Yeah, I think he talked about trademarks. So that's why.
So, how much time after you are allocated your trademark in India can you avail the Madrid Protocol?
I don't know the answer to that question. The exact
I think
thing.
1 year?
Yeah, I'm not sure. I don't know whether it's 6 months or 1 year. I don't know.
So 1 year after your request is approved, or 1 year after you file in India?
After, I think it's the filing date.
Filing date.
I think it's the date. But I'll answer that question to you later.
And one question about that black holer thought process, and both of them started working on it. One guy decided to file a provisional patent, but he kind of left it alone. He did not actually work on it and then come up with a product or anything out of it. The other guy, he went ahead and then actually created a viable product which can be monetized, went ahead and created a company around it, sold the products. Now, since the other guy has now filed for the patent, this guy did not, who would get the benefit of the doubt there? True product.
That doesn't matter.
Just if it is on the paper,
No,
just an
yeah,
idea.
yeah, absolutely. First of all,
He's the smart guy.
yeah.
He's letting the other guy do all the work. Right?
Yeah. Just stop me whenever I need to.
I have a question.
Yeah, please.
Basic question.
Yeah.
What are things we have to submit for the filing? Or just send a mail, or is there any?
Yeah, actually, the patent filing process is very, very systematic. Okay, you work with any patent firm, right? You file a one-page disclosure of your idea. Okay, the moment it goes to 2 pages, then you're confusing yourself and the other person, because they actually do the patent search for 1 page. In fact, 1 paragraph, and you're a genius. Okay, so because we have to crystallize it into just the claim elements, and we do the search based on a paragraph of concepts. So that's all you need. Okay. Next is within a couple of weeks they'll get back to you, and then you give them like a description of each element. And again, it has nothing to do with the number of pages. The best patents are less than 2 pages. Okay. So it's usually a couple of pages to say, if you have a lot of screenshots, it may run into tens of pages. Okay. So that's all it takes. And then it takes about 3 to 6 weeks to go through this process.
But I heard from somebody that we have to submit the 4 copies of the source code and something like that.
It depends. It depends. I don't think you need to submit your source code at this point. Post the Alice decision, I am not sure. They are asking for copies of the actual running program. Okay, but that's still iffy. But right now, all you need is a proper algorithm description to file. Yeah.
Sure. Sorry. The final one in US. Still the provisional one is filed in India.
Yeah. Any country you can file, it's irrespective, anywhere. The Patent Cooperation Treaty ensures that any country in the world you file, that particular date is your first day of filing for all reasons.
13-month window that you get because you are
PCT, yeah.
So that is after, within that 1 year, so you get 13 plus 1 year?
No, 30 months. Total 30 months from the date of first filing, whatever, provisional or not.
So I'm in India and now waiting for the grant phase, and I also apply for PCT, right? Because I would like to file a patent in other geographies, for example, US in this case. But I have filed the patent in India, but have not yet filed PCT. There are chances that when I file the patent in US, there is already a patent. Right?
No. See, again, see when they do anywhere they do a search, right, they consider all the patent databases all over the world. So it's again first day of filing.
Okay.
That's it. Simple. That's good.
Yeah.
Yeah.
Maybe we can take the last two questions. If you have on any subject.
Through Indian office.
It's your choice. Just make the choice and tell your patent firm, and they'll do it for you.
We don't need any permission from the Indian office.
Yes, you need. So they will have to apply for that. So what we do is, listen, by the time you apply for that and you actually ask them to do that, just file it in India. You still get the date.
Still need to get a permission and then file.
Yeah, you can. It's your choice, really.
It's a fairly straightforward process.
It's very straightforward, very established process. Yeah.
So if you have a company in the US and a company in India, and the Indian entity has trademarks that are filed, but only for India, because we have to look at what you mentioned, the Madrid Protocol or...
Exactly, yes, correct.
And that would be worldwide for 13 months.
Correct.
So,
Worldwide, yes. See, so until recently, we had to file the Madrid Protocol through the US. Now that's changed. We can do it right from here. So,
is there any benefit in the window of those 4 years that, you would have filed for a patent that you believe in the full industry that it will come through, and then in the meantime you're talking to investors and wherever. So is there a value of that?
oh yeah, tremendous value. Believe it or not, the investor is looking at intellectual property, okay, and they understand that it takes time to get it through. Okay, so whether it's just a file patent or not, it is equally important to the investor.
I would add, investors don't know anything, right? I would say investors don't know anything. So that's one way you can fool them by saying my technology is so valuable because I believe in it enough to file a patent.
I getting some other people who are more who will be more like co-owners, founders with us. We are already 1.5 years, and what is the best way to get them in? We are not looking at giving salaries, but we are looking at giving some form of stocks. Is it ESOPs or is it some sale of stocks, or what should be the path we should take?
Sure. So an ESOP is a right for future ownership. So it could be a period that you might come up with. But if you are making them as, I heard you say co-founder level, then perhaps they may be looking for shares itself. So the question is option versus sweat equity. If it is sweat equity, then it is an allocation for no cash investment. And based on the value when you're allotting shares, to whatever that value is payable as a tax. Now, if he's an employee granted sweat equity, then it gets taxed as perquisite tax. If he pays, say, at face value or whatever, because there is no precedent of a previous valuation that's come by, then he purchases shares. If it is a purchase of shares, there's no tax.
But the short answer is also, if you're early on, it's better because the value of the underlying shares is low enough to issue shares outright. As the value goes up, the ability for an individual to write large checks. Because keep in mind, it always has to be at the fair market value at the time of issuance. So on day one, the underlying price is low, so you might as well issue shares. Have them write a check for the underlying price. As the value goes up, so if you bring a co-founder, let's say after you raise Series A funding, then they'll have to write a check for a large amount. So even for a co-founder at that point, you may want to issue options instead of having stocks.
So before any funding, the valuation is as much as the share capital that you put?
Well, unless you file patents and other things, right? But
or customer contracts, revenues coming in.
But funding does certainly put a bright line, right? It can't be lower than that because an outside party is already invested money. So the company's ability to price the shares at a lower prices goes away once the third parties put in and value the company at a certain valuation.
Then how do I find the fair value?
Before or after the funding?
Even before.
A chartered accountant can.
And I need a kind of a proof of a fair value before
it's better to establish that, because then it becomes easier for your tax filings, easier for you to determine the exercise price and the difference that goes as a taxation. But if it is a co-founder, then options is difficult. So it's got to be sweat equity route for you.
For an India company.
For India company, yeah.
Meaning the 10% kind of
yes,
limit
yes,
will...
yes.
Thanks.
Anil was speaking. I asked a question on, okay, in our case, the patent filing is in the individual names of the founders, because that time the company was not incorporated. Now, if we go for a US entity and all that, then how would it, in a recommended way to work, is how would it be? We assign that IP to US entity, the individuals transfer the rights to the US entity. Is that how it is, or is there any other way?
It's an assignment.
Right. In the US, you would do that as part of the consideration for buying the shares in the US company. So you'll do it at the same time. The US company would issue you shares in exchange for, among other things, assignment of the IP. And you'll need a permission from the local PTO.
Okay. And then what happens if the patent is granted in one jurisdiction, not granted in another jurisdiction? Then how is the IP assignment and all that? So, for example...
See, an IP is an asset, right? It doesn't, so irrespective of where it is granted, you even for an application you could assign your assets. So...
No, so going back to that, we being in India, we file first with the Indian office, and then within 12 months or whatever, we file in the US. And if we are not granted in India, but we are granted in the US, and that is technically possible, right?
Yes.
Yeah. So how does it work in that case?
No, when you assign your patents, every application is an individual asset. Like if you have a patent, and you file it in India, and then in the US, and then in Germany, each one is an individual asset. Each one has to be individually assigned. There's nothing like a patent which has all these three in it. They're all different. They're considered different entities and assets. So you have to treat one individually and assign each one individually.
So I guess the question, or the sub-question is, so you get the patent in US, do you then file in India to protect that patent in India?
Yes. So you would have to do that within the first year of filing it itself. So you're locked in there. So you would have made the decision earlier.
That was the last question, so.
Yes, that is the last question. Thank you so much. No, it's
Okay.
great. No, sit. Right? You all have earned yourself a good lunch, so I need to make an announcement on that. But before that, I think the involvement from all of you was very, very good, very nice, and I could see a lot of people, a lot of questions over here. In fact, I have to deliberately stop this session. But that shows, the speakers have done a fantastic job here. It was a lot of applause for all of you.